Application for noting
Application?
of noting of deaths, MSCC case.
Application for inclusion in the list.
Application?
For inclusion in the list. Limitation application.
Oh, Liplin, yes, give it.
Section 5 application lordship.
Yes, have you sub copy upon the other side?
Lordship, one matter more lordship. Lordship, serial number 124 lordship. On last Friday, I have mentioned that matter lordship, and your lordship directed to place this matter on today lordship.
124.
Lordship. But lordship, this matter has not appeared lordship.
Okay, let 124 appear as to be mentioned tomorrow.
Itu dag diye রাখবেন কাইন্ডলি,
124.
124 lordship. 5 of lordship.
My lord, one matter, my lord, your lord, motor accident claim appeal. My lord, your lordship was heard it on 29th. Your lordship heard it on 29th and delivered the judgment. But my lord, that has not yet been uploaded in the server.
Give the slip.
Only.
Yes, give the slip.
Tender my apology lordship. 26 lordship.
যে জাজমেন্টটা ডেলিভারি হচ্ছে ওটা আপলোড হয়নি, ওটা সই হয়েছে কি?
126
ওর যে একটা জাজমেন্ট ডেলিভারি যে 29th-এ 29th-এ জাজমেন্ট হয়েছে, 29 মানে 30 শুক্রের আগের দিন, বৃহস্পতিবার দিন, ওটাই আপলোড সার্কিট না এখানে এমভি অ্যাক্টে ওটা বোধহয় সই মানে রিটাইপ করতে পাঠিয়েছিলাম, সম্ভবত সই হয়নি, ওটা একটু দেখে নেবেন, না হলে পাঠাবেন। ইয়েস, গিভ দ্য স্লিপ।
Only 8 weeks time has been allotted, my lord. For
No, from the date of communication.
That one thing, my lord.
My lord, yesterday week, my lord, one matter, that is dishonor of check, my lord, where Mr. Singh, my lord, appearing for the National Insurance Company, I am for the appellate. The original award was passed and it was modified by way of review petitions.
Yes, I've
Yes.
concluded the hearing.
Concluded, my lord, I want to file the, my lord, written notes of arguing, which the, my lord, the decisions I am one copy I am submitting. Let it be kept with the record, my lord. এটা দিন না জজ সাহেব নিচ্ছে তো, আপনি জজ সাহেবের ওপরে নাকি?
Yes, give that.
ওই যে ওইটা
থাক এটা অর্বে। So let it appear tomorrow as to be mentioned. No, probably you have given all these decisions.
Yes, my lord, kindly keep it, my lord, with the file, my lord.
Because already you have submitted some of the decisions.
Because under the Motor Vehicle Act, review is not maintainable.
Okay.
Lordship, may I be permitted to make a mention?
Yes. Mention for?
Yes, sir.
Mention?
Mention for extension of order.
Yes, give it to be mentioned.
Item 7, my lord, yesterday, it was not this week yesterday, appearing by mistake.
Okay, item 7, let it be not this week.
Item 8, my lord, I am for the respondent insurance company. I beg my pardon, my lord. It was fixed yesterday. I could not appear because I had to go to my daughter's school, my lord. That's why I beg my pardon.
I'm just fixing it again tomorrow.
My lord,
Yes.
I'm grateful.
Record an order. আচ্ছা দাঁড়া, হ্যাঁ না ফিক্স করে দেওয়া হচ্ছে। হ্যাঁ আচ্ছা, কালকে 10:30 কটা ম্যাটার আছে? কাল বা পরশু দিন দেখুন তো।
4th or 6th, my lord.
দেখুন 5 তারিখে 10:30 কটা?
My lord, 6th, my lord, kindly.
5 তারিখে দেখুন
My
10:30।
on paper, she has difficulty, my lord.
আচ্ছা, yes, record an order. Learned and for the parties are present, let this matter be fixed on 5 2,
My
2026.
lord, 6, my lord, kindly, my lord, 6, or not on 5, my lord. 6.
Acha. 6/2/2026 at 10:30 a.m.
My lord, I am grateful, my lord. I am deeply obliged.
Much obliged to your lordship.
Yes, item 9.
In my lord, I am for the appeal in my lord. There is a direction for preparation of paper book, my lord. I have collected my lord, certificate copy from the TCR, my lord. There are some documents are missing. That is why, my lord, I could not prepare. My lord, I have also, my lord, instruct my client since this appeal relates to pertains to my lord already quantum of compensation. I asked my lord, my client to settle the issue before the ensuing local.
Anyway, if your client is agreeable, well
Yes,
and
my lord,
good.
kindly grant
I'm
me, my
keeping
lord.
it after 4 weeks.
Yes. Meanwhile, I shall come.
Record an order. Let this learned advocate for the appellant is present. Time to file the paper books stands extended for a period of 4 weeks. Let this matter appear after 4 weeks under the same heading.
Get put.
Yes, item 11.
Yes, Lord, today was fixed from Lord filing of written arguments only. Lord, may I file my brief note?
Yes, yes. Yes, record an order.
Lord, I have already, Lord, annexed 2 judgments which I need to cite, Lord, and the copy of the Black's Law Dictionary, Lord.
Learned advocate for the appellant is present. Written notes of arguments filed by the learned advocate for the appellant be kept with the record. As hearing of the appeal is concluded, let it be reserved for judgment.
Great. Great.
My lord, this appeal was appearing in your lordship list. My lord, on mentioning it will appear as to be mentioned for fixing a date, because the only point involved in this appeal that 8 days delay in lodging FIR. My lord, your lordship is aware, but there are
Yes,
several-
record an order.
kindly fix a date particular.
Learned advocates for the parties are present. As the paper books have been filed and the matter is ready for hearing, let this matter appear for hearing on এই 9 তারিখ দেখুন তো কোনো ইয়ে আছে 10:30 ফিক্সড আছে
এই জজ সাহেব কি বলছে সিদ্ধার্থ দা?
9 তারিখ দেখুন 10:30 কোনো ফিক্সড আছে কিনা হ্যাঁ এমএ মানে এমভি মানে মোটর ভেহিকলস কেস এই মানে মোটর ক্লাব আর ইয়েতে 10 তারিখ দেখুন ওকে 10/2/2026 at 10:30 a.m.
Sir, I'm paying for not today in this 13 and 14.
Okay, not today.
Item 15, my lord, I'm for the respondent, my lord. My lord, the appellant is not there, my lord.
Paper books are ready.
Yes, my lord. Paper book has already been filed, my lord. Kindly, my lord, posted in the hearing list, my lord.
Yes, record an order. Learned advocate for the appellant is present.
Respondent, my lord.
Respondent is present. As the paper books have been filed and the matter is ready for hearing, let this matter appear for hearing on 11/2/2026. Actually, 12/2/2026 at 10:30 a.m.
My lord, I am for the appellant. The action should be given for the preparation of paper book and LCR should be called for, my lord.
Yes, record an order.
I am filing
Learned
the affidavit
advocate
in
for the appellant is present.
16 I appear for the authority.
Learned advocates for the parties are present.
I will give you paper.
Let the trial court records be called for. and the paper books be filed on the arrival of the trial court records. Let this matter appear after 4 weeks.
Ma'am. After 4 weeks, my lord, one date should be given, my lord.
4 weeks you mentioned, if it does not appear,
Naam ki.
after preparing paper books you mentioned.
Okay.
17, my lord, I am appearing on behalf of the appellant insurance company.
Paper books are ready.
My lord, no, paper books are not ready. On the last occasion, my lord, my stay had been made absolute and the owner was directed to appear personally.
Where is that order?
That is order dated 17th of July 2025 and probably TCR was also called for. If not, then my lord will kindly call
So
for the
paper
TCR.
books have to be prepared.
Yes. If not, my lord will kindly call for the TCR so that
Please record an order. Learned advocates for the parties are present. As the trial court's records have not come, the trial court's records are called for at the special messenger cost of the respondent number 1. The paper books be prepared on arrival of the trial court records. Let this matter appear after 4 weeks.
my lord.
Liberty to mention.
Special messenger.
Record call for
Yes.
normal cost.
Without
Yeah,
he's saying without special messenger cost,
Provided the
it
cost
should be
that-
called on normally.
Special messenger cost কেটে দিন হ্যাঁ তাহলে let this matter appear after 6 weeks করে দিন
6 weeks. My lord. Grateful, my lord.
না কন্টেম্প ম্যাটারটা একটু ধরে নিন আর না কন্টেম্প ম্যাটার কটা আছে yes contempt matters
Contempt matter, my lord, I am.
both sides are present.
No, my lord, my learned friend was requesting me yesterday that he will not available. His junior will be available. for
Okay, anyway, let
meeting
it remain
one
in the
time.
list. Okay. Yes, call the fixed matters.
Yes.
It to be mentioned to
Much of it.
11. ওটা জমা দিতে হবে আমাদের রিটেন নোটস আর্গুমেন্টটা না আমাদের জমা দিতে রেসপন্ডেন্টে জমা দিতে হয়
My lord will
রেসপন্ডেন্টে জমা
call up the application.
No, I'll take fixed matters. Thereafter, after 12:30, the applications will be called on.
রেসপন্ডেন্টের আছে
Appellant.
মাই লর্ড
So probably respondents have earlier filed.
yes
Earlier have already filed.
no my lord today was the date fixed
তাহলে ওইখানে অর্ডারটা ইয়ে করে দেবেন learned advocates
I'm
for
filing.
the appellant and learned advocate for the respondents file written notes of
yes
argument.
notes of argument and my lord reference
Yes, along with the
reference
reference. Give it in a compilation forms. Have you indicated that it
Yes,
is
yes,
filed
yes.
by the respondent?
yes
No, on the head of,
yes
otherwise
it has
how,
it has
no.
been mentioned my lord
on the top of the judgments, have you mentioned it is by the respondent or appellant?
no my lord
Otherwise it will be confused.
I'm indicating it my lord.
Yes.
Yes. এই এগুলো দিন তো একটু লিখে দিচ্ছি
Number 3 and 4. 3 and 4, my lord. I am from the respondent cross objector. Mr. Shomil Ganguly, I called him over phone.
You are for the appellant.
I'm for the respondent cross objector.
Yes.
Lordship, I'm there for the petitioner. My senior is coming. Let him start.
My lord, I'm for the respondent cross objector. My lord, first thing is that, my lord, no proper ground has been given in the memo of appeal. In the memo of appeal, your lordship will find.
No. This is first of all, let us take your appeal. Item number 3. Magma HDI General.
I'm for the respondent claimant, my lord. Respondent cross objector.
You're for the respondent claimant.
Respondent claimant cross objector.
So let the appellant insurance company come, otherwise let it be not today.
Possible. No, my lord.
Can't
Let it
you
be
make it a passover?
kept a pass as passover.
Okay, pass over.
Wait.
Lordship, this is insurance company's appeal, Lordship.
In this matter, I am appearing for the respondent.
Lordship, the main grounds, Lordship, in this case, Lordship, an accident took, alleged accident took place on 20th of January 2021, Lordship. These are death case, Lordship, filed MSCC case filed under section 166 of Motor Vehicles Act, Lordship. Lordship, the deceased was Topon Das, and Uma Das had the wife and the family members, children. The deceased claimed to be a seasonal businessman and a driver, Lordship.
Yes.
Lordship, in this case, the main points of appeal, Lordship. One is the income was not properly proved, Lordship. He claims to be a seasonal businessman and a driver, and the learned tribunal has considered income as rupees 10,000 per month, Lordship. But in support of income, no income proof was given. Only a document, and it comes to page 68-69, Lordship. That is also not exhibited. A document issued by Sukumar Ghosh Transport, dated March after the accident, 28/8/2021, Lordship.
No, which page? Page 68.
Page 68, Lordship.
68.
It is marked
It is
X for identification.
It is not exhibited, Lordship. That document was produced, and another one is 69, Lordship. These documents were filed, but none appear to be deposed before the learned trial court to exhibit these documents.
So what
One
is
is
his occupation claimed by him?
Claimed by him, in the claim, it is stated that seasonal businessman and a driver, Lordship. Claim petition I am coming.
So far, driver is there. One document was filed.
That was dated March after his demise, Lordship, by one Sukumar Ghosh. He was never
That means after filing the case.
After filing the case, during trial, a manipulated document, a typed copy. During his tenure, nothing was no
Panchayat.
Panchayat person said that I knew that. He was a driver.
Under whom he was driving. Car was driving.
But he was not brought as a witness, Lordship. And apart from these two documents, nothing was exhibited.
Oh.
It was filed and
just a minute.
For identification.
The claim petition is page number 1, Lordship. Here it is a seasonal businessman and a driver. And the monthly...
Businessman and a driver.
Huh.
What was the nature of the business?
Nothing was came forward, Lordship.
Let me
Lordship, kindly. Lordship, kindly comes to the depositions, page number 15 of the wife of the deceased. Page number 16, Lordship.
Page 16.
Paragraph 8, Lordship. That my husband was a driver by profession under Sukumar Ghosh. He used to earn rupees 21,000 per month. But nothing in support of this.
Any driving license?
Nothing.
Yes, driving license was produced.
Where, which?
Which page?
Kindly see.
Which page? Oh, page 67.
13. But no income proof. Only a license was. No income proof
And
was
how
given.
much was the notional income considered by
10,000 was considered. It was considered as a skilled labor, and 10,000 was given. The judgmenting portion.
10,000 and minimum wages act was applied.
No, it was written.
Year 2021.
Lordship, my appeal, let me allow to submit, Lordship.
Yes.
Page 33.
Page 33.
Rupees 300 per day.
No, just a minute. This is
page 34 is the
page 33.
33 and 34. He was considered as a skilled labor. Deceased was a driver, and definitely he was a skilled worker.
No, here the claimant's case was that the victim used to earn rupees 21,000 per month.
That is there in the depositions.
21,000 per month. That
Mm.
is the victim's assertion. But in support of that, no,
No
documents
documents.
were
Mm.
submitted. Okay.
Yes, Your Worship.
21,000 was claimed, but
Mm.
no documents were
Documents was
submitted.
no proof was given.
Say gave save and accept certificate.
Certificate, and that is issued after his demise.
No, during the pendency of the case.
During
Okay.
the that is a manipulate only a
Because you
date.
see,
Only the
because you see, certificate
And-
definitely has to be issued when it is required.
driver,
Earlier to accident, nobody
but the
did.
driver did not came forward to depose that document.
No, question is,
Mane the employer.
document is filed, but that is not exhibited.
That is marked as X. Identification.
21,000.
Hmm.
Okay. So, considering,
But Shukumar Ghosh was not examined.
so
The
examination,
person who issued this one.
yes, only two witnesses were examined. One is the
One is
victim's
the
family.
victim's family, and one claims to be an eyewitness. And rest are the opposite party witnesses. Lordship, my next point.
Yes.
Lordship, my next point is in this case, no road permit was, the offending vehicle did not have any road permit. Even in the seizure list, that was not seized.
Was this point argued before the trial court?
It was taken in our written
Where?
statement. Written statement, it was taken, page number 9, Lordship. The written statement filed. Not considered.
Any evidence adduced with regard to that motor vehicles authority examined?
No, Lordship. But in the written statement, it was taken.
Yes, you may take in the written statement. Did you adduce any evidence with regard to that?
No, Lordship. In page 9, it was taken, Lordship. Paragraph 25.
Page 9.
Page 9. Written statement starting from page 5, it is in page 9, paragraph 25.
Page 9, paragraph
25. That the aforesaid alleged vehicle had no road permit to carry passengers.
Route one.
A route permit.
Yes, anything else?
Lordship, another thing is, in this case, Lordship, kindly exhibit D, Lordship. It is claimed in the claim petition that the deceased died in the Midnapur Medical Hospital. But an RTI application was made, but it is stated page number 120, Lordship. This is also exhibited that no medical records were found in the Midnapur Medical College and Hospital, Lordship. Page 118 is the letter.
No, who is this this applicant here?
Applicant is the investigator, investigator of the insurance company. That this is also corroborated by the evidence of OPW.
PW?
OPW2, Your Lordship. Kindly come. Page number 21, it is starting.
Page.
He has exhibited this document. And it is exhibit D.
The postmortem reports, all these were exhibited.
Postmortem was exhibited, but it shows that it is issued from Midnapur Medical Hospital. But
Postmortem report.
that is written. Let me see. Postmortem at page 91. Department of FNT, Midnapur Medical College. Page 93.
Yes.
Stamp is. না 93 তো আছে সেম আছে 62 63 93 same.
So far, postmortem report is concerned,
It is
there is no
issued.
dispute with regard to this.
That
Because
is
this
there.
was verified.
That is there, but RTI reply.
No, maybe, but so far the death due to accident, postmortem
Death
report.
was there.
No,
but
postmortem report. What is the postmortem report?
Postmortem report is death due to the occurrence of injuries. That is there, but
Yes, road tax. The investigation was done. Charge sheet was submitted.
Yes.
but when RTI was made, they have
The
we do
RTA
not
was
have
made.
any
RTA was made with regard to hospitalization,
Hmm.
as well as probably with regard to this verification of the postmortem report.
But that is
Now, bedded ticket.
no
He
such
was
record
brought-
was
he
found.
Brought to the hospital and declared a broad date. Where is the
But
bedded
no
ticket?
such
You are not
record
admitted.
found. But no record is found that is dated.
Oh, he was brought dead to the hospital.
Yes, my lord, what are the questions,
Just a
my
minute,
lord,
just a minute.
information the report? Your lordship kindly see the page 118. What are the questions, my lord? Query. Kindly provide the bedded ticket. Kindly provide the injury report. Please provide the certified copy of discharge certificate. He was not admitted. He was not
But
injured.
no record found.
On the spot, he
No record.
declared dead.
The postmortem report from the Self-Same hospital.
Yes.
Postmortem report was issued
From which hospital?
from
Midnapur Medical.
Midnapur Medical Hospital.
Page 63.
Page 82 is also there. Oh, there is broad dead.
Broad
Page
date.
82.
Page 82.
There is no
Midnapur
question
Medical
of-
College and
But
Hospital.
no record found.
No, this. That means, did you send this one for verification, whether this is genuine or not?
No.
No, only the RTI was sent.
You should send this. This copy was not sent. This is a government document. Investigation was done by the police authority. Yes, that's all.
And one thing, Lordship, I don't have much evidence in that. Only in the chief it is stated by the OPW2. Two accidents were made within a period of 6 months.
Two accidents?
This offending vehicle, he has made 2 accidents within.
Whatever it is,
that
how
is-
this can be decided in
that is
this case.
Yes, Lordship, that is.
Yes.
that's why. ঠিক আছে বলুন
Now, my lord, 3 points, my lord. were highlighted by my learned friend. That is the income disputes. My lord, kindly see the evidence of my lord, the wife of the my lord, the disease. Page 15 to 17. My lord, Uma Das, she was the wife of the disease. My lord says that my husband used to earn rupees 21,000.
Yes.
15 to 17. My lord, page 16, paragraph 8. Got it? My husband was a driver by profession under Sukumar Ghosh. He used to earn rupees 21,000 per month. And kindly see, my lord, exhibit 13, the driving license of the disease at page 64 to 69. My lord, I am giving the driving license.
64 is the Aadhaar card.
Oh. Kindly see page 66. That is the, my lord, page, your lordship got it, page 66. Driving license. My lord, it was, my lord, valid.
There is no written validity. It is issue date, only date of issuance is given.
Date
It
of
was
birth.
exhibited.
Yes, it has exhibited. Exhibit, my lord, mark as.
Exhibit
No, my lord, it was marked as exhibit 7. Exhibit 6. 6 to exhibit 6.
only the date of issuance is
My lord,
given.
kindly
Validity
see
period
the,
is
my
not.
lord, the
It was exhibited after all.
exhibit 13. My lord, page
Very well,
17.
very well. Yes. Anything else?
My lord,
Page 70.
my lord, Supreme Court, considering the, my lord, the judgment, one judgment, that, my lord, I require. My lord, here the claim. Copy নিয়েছিস? না, না. Considering the judgment, my lord, considering the number of families, my lord. My lord, it is very, my lord, ill luck, my lord, for my lord, I have not filed any cross objections. My lord, though the income was, my lord, but stated in the claim application, also the position 21,000. But the learned tribunal considering that judgments, my lord. My lord, দে আমাকে দে। আচ্ছা 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 আচ্ছা। Considering the number of the families, here the, my lord, the number of the families are, my lord, wife, minor son, minor daughter, and parents of the disease. There are 5, my lord, 6 numbers, but 5, my lord, are entitled. Learned tribunal, my lord, took, my lord, considering that judgment is 10,000. My lord, the accident took place, my lord, 2021. Minimum wages says, my lord, the driver of that period is, my lord, about 9,000 to, that is per day 300. Kindly consider in 2021, if I appoint a driver, I can, my lord, Give him, my lord, 10,000, he will not work with me. 10,000, my lord, my learned friends, is arbitrary. Considering the decision of the Supreme Court and considering the minimum wages, that was also considered, my lord, that was said, my lord, by the learned tribunal, that I have taken the income of the deceased, who was the driver, and my lord, is a seasonal business of Mursumi. That was given by lord, the Panchayat Pradhan says that he used to run also the Mursumi business. And considering the number of family, 5 numbers in a family, 10,000, my lord, is not exorbitant. And second, my lord, this is the income. Income, my lord, which has been taken, my lord, I am not disputing. My lord, it is, my lord, first beginning says I have not, my lord, prefer any cross objection. If it is cross objection, it would be higher, my lord, I pay. But 10,000, my lord, that was considered by the tribunals, that I will accept. Now, my lord, regarding road permit, my lord, indeed, my lord, there are, my lord, caton of judgments. If a, my lord, the insurance company puts a questions regarding driving license, route permit, there must be some, my lord, the evidence from the side of the, my lord, the motor vehicle department, or from the, my lord, the owner, or from the, my lord, the driver. Well, there is no evidence. Evidence is from the insurance company, is the, my lord, OPW1 Minal Kanti Poti is a summoned witness. He brought the, my lord, it is also very much, my lord, support me. He also brought the, my lord, the inquest report. My lord, kindly see page 20. Page 20. At present, I am posted at SI Police. Madam, may I permitted to read? At present, I am posted at SI Police at Kotwali Police. I have some to depose in connection with this case. This is summons from this order on Puriato. I was posted the same place in the same post. I have brought with the certificate to be true copy of the inquiry report Tapon Das, Kotwali in connection with the case number so and so. This is the certificate to be true copy of the inquiry report. Now, cross-examination by the petitioner. I did not perform the inquiry report. I am not the IO of this case. I did not investigate the case, nor did submit the charge sheet. I have no personal knowledge regarding the case. And my lord, regarding the, my lord, the charge sheet. Now, my lord, regarding the, my lord, the charge sheet, it was charge sheet, my lord, your lordship, kindly page 51 to 56. The IO, my lord, investigated the matter, and my lord, taken 161 statement from defined witnesses, including my lord Uma Das. Page 53, the particulars of witness to be examined, Uma Das. And also other, my lord, the doctors, and my lord, the SI, and he submitted that the he submitted the charge sheet against the, my lord, the driver of the, my lord, offending vehicle. Offending vehicle is the, my lord, is a tractor. Is a tractor WB 33B647G.
This list of witnesses are to be examined during trial. These are not 161 statement witnesses.
Now, my lord, so far as the income, my lord, I am saying, so far as the road permit, my lord, nothing was, my lord, brought on record that at the time of accident, the offending vehicle tractor had no valid permit. In the charge sheet, it did not reflect. So, my lord, assumption, presumption, my lord, cannot be, my lord.
Lordship, in the charge sheet, the Caesar list is no, there is no Caesar of any route permit. Can you see
After in a,
paragraph
my lord, in a
11?
village area, my lord, there is a commercial
Registration
vehicle.
certificate, insurance
Can be
policy,
used in
DL.
a agricultural purpose.
How many witnesses were examined by the opposite party?
Oh, two.
One is the
One is
ASI.
the SI
ASI.
who brought the inquest report.
Okay, the other is
Other is the
Secretary
legal
of the
officer,
legal
legal officer. He says that in my lord, between my lord 6 months, my lord, there are 2 accidents, no documents.
no. Where is the legal officer statement?
Legal affairs statement is
21 onwards.
page 21 to 24.
No, legal officer statement 21 to 24.
21 to 24.
He says that I have filed the information slip. He was the assistant legal manager of Future General Insurance Company, which I posted as assistant manager legal TP in Kolkata office. Now, my lord, the paragraph 7. During the same policy period, the policy by number so there are 2 accidents arising out of the same policy period with a gap of 6 months, which indicate fraudulent involvement. What is the documents, my lord, that the 2 accidents? My lord, evidence, my lord, it can be accepted. Without my lord document, there are 2 accidents. There is a claim. And thirdly, my lord, paragraph 8. The claimant also failed to supply scrap of document supporting statement, and disease Tapandas was a signal business, also failed to prove the disease was 39 years. As per Aadhaar card, he was 39. There, paragraph 10, that there was inordinate delay on the part of the to proceed with the case. The FIR was lodged, after 12 days. Because at that time there is a COVID period. And my lord, in the FIR, my lord, what the FIR says, my lord, your lordship kindly see the, my lord, page 44 to 47. My lord, page 48. Page 48. To the IC Kotwali PS. আমার মানে মে আই পারমিটেড টু আমার বিনীত নিবেদন যে আমি উমা দাস, আমি তপন দাস সুয়াংশ আপনাকে জানাইতেছি গত ইংরাজি 20/1 এত তারিখে আনুমানিক 8:45 নাগাদ আমার স্বামী তপন দাস উদয়পুর 5টা পিচ রাস্তার আনবাড়ির নিকট রাস্তার বাম দিকে মোড়া অংশে দাঁড়িয়ে প্রস্তাব করছে। ঠিক সেই সময় উদয়পুর দিক থেকে আসা ট্র্যাক্টর নাম্বার সুয়াংশ গতিতে বেপরোয়া ভাবে গ্রামে আমার স্বামীকে ম্যাটারোর ধাক্কা মারে। এর ফলে আমার স্বামী রাস্তায় ছিটকে পড়ে এবং গুরুতর আঘাতপ্রাপ্ত। স্থানীয় লোকজন আমার স্বামীকে তুলে মেডিকেল হাসপাতালে নিয়ে গেলে উক্ত হাসপাতালের কর্তব্যরত ডাক্তারবাবু আমার স্বামীকে পরীক্ষা করে মৃত ঘোষণা করে। উক্ত ঘটনাটি WB নাম্বার নাম্বারটি ট্রাক্টর চালকের দ্রুত বেপরোয়া ভাবে চালানোর জন্য অতএব দোষী চালকের বিরুদ্ধে প্রয়োজনীয় আইনানুগ ব্যবস্থার জন্য অনুরোধ করতে। কাইন্ডলি নোটেড, মানে নেক্সট প্যারাগ্রাফ উল্লেখ থাকে যে আমার স্বামীর মৃত্যুর পর মানসিকভাবে বিপর্যস্ত এবং শোকাহত এবং ধর্মীয় আচার অনুষ্ঠানের কাজে ব্যস্ত থাকার জন্য অভিযোগ জানাতে বিলম্ব হইল। মালাড রবি ভার্সেস বদ্রীনারায়ণ, it is clear in Indian society this is not a case that just after accident, without treating the injured person, without performing ritual programs, the person was compelled to rush to the police station and lodge a diary. And delay in lodging, is not a ground to defeat the claim of compensation. It is settled law. Now, if your lordship want to see Robi versus Bodhinath, your lordship has considered many judgments, and I can produce. I have brought. And Mita Shamanto also, my lord, says regarding route permit and regarding the involvement of the vehicle, if the insurance company took the leave, 170, of the motor vehicle, it is the insurance company's duty to put, my lord, the driver owner before the, my lord, dock. My lord, if it not discharged, has been, my lord, inferred that the offending vehicle was involved and my lord, there is a rash and negligence. And Mita Samanto also, my lord, followed by the division bench Dipankar Datta in Pratibha Bari's case. That is also, my lord, Robi versus Bodhinaran, and also Mita Samanto has been followed by our division bench. I bought that decision. I did not place. If your lordship do not desire. So, my lord, the appeal is totally, my lord, misconceived without any, my lord, valid grounds. The appeal is liable to be dismissed with cause.
Yes, anything to add?
Lordship, in this case, income, these are the points I have already
Yes,
mentioned.
take down.
And
Learned,
the Caesar list is there, police did not seize
learned
the
advocate
permit.
for the appellant, insurance company, and learned advocate for the respondent number 1, 2, 3, 4, and 5. 5 respondents.
There are
Five
five
respondents.
Claimants are present. Hard learned advocates. The appellant insurance company before this court was an opposite party in a claim under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 6th day of March 2024 passed by learned additional district judge, first track, second court, Paschim Medinipur in MSC case number 206 of 2021. Stop. The case, next para, of the claimants, respondents number 1 to 5 may be summed up thus. On 21, 2021, at about 8:45 hours, when the victim was doing urinal on the roadside of Udaipur Pathra Road, Moram portion near Arbadi on his left side. At that time, one tractor bearing number WB-33 capital D stroke 6470 coming from the side of Udaipur with very high speed and rash and negligent manner, endangering to human life and safety, dashed the victim Topon Das. Stop. As a result, victim Topon Das was seriously injured, and with the help of local people, he was shifted to Midnapur Medical College and Hospital. And after examination, doctor of said hospital declared him dead. Stop. The accident took place due to rash and negligent driving of the driver of the offending vehicle bearing number WB 33 capital D stroke 6470 tractor. Pursuant to the filing of the case, notice was issued upon the insurance company and the vehicle owner. The insurance company, the appellant herein, contested the case by filing written statement and adducing evidence. Although opposite party owner filed written statement but did not contest the case. Stop. Issues were framed and evidence were adduced by the appellant and respondents number 1 to 5. Upon considering the evidence adduced and upon hearing the learned advocates, the learned trial judge was pleased to dispose of the claim case by observing and directing as follows. Quote, page 35, again. hold it. The appellant, Future Generali India Insurance Company Limited, being aggrieved by the judgment and award passed by the learned trial court, has come up with the instant appeal. Stop. Hard learned advocates for the appellant insurance company and learned advocates for the respondents number 1 to 5 stroke claimants. Peruse the materials on record. Learned advocate for the appellant submits that the issue of income was not properly considered by the learned trial judge, and the learned trial judge, without any support of the documents with regard to income, considered the income of the victim to be rupees 10,000. Learned advocate further submits, although there is a violation of the condition of the policy, as the vehicle was not covered by the route permit, but there is no such observation made by the learned trial judge. It is also submitted by the learned advocate that the legal manager, although conducted inquiry with regard to the hospitalization of the victim, but the superintendent cum vice principal, Midnapur Medical College and Hospital, furnished the information that no records were found in the name of Topon Das at that time. Stop. Learned advocate for the respondent number 1 to 5 stroke claimants submits that the learned judge rightly considered the issue of notional income of rupees 10,000 and has rightly come to the conclusion by awarding the reasonable compensation. Learned advocate relies upon the decision in the case of Maheshwari and others versus Ramachandran and others, reported in 2023 within bracket 1 TSC 387 SC. Learned advocate further submits that as the victim was brought dead before at the hospital, there is no question of any treatment of the victim which was sought for by the legal manager of the insurance company. Learned advocate also submits that although allegation was made with regard to the violation of the conditions of policy, but no evidence was adduced in this regard. Stop. Before proceeding to decide on the issue with regard to the death of the victim by accident, which is disputed by the insurance company, it appears from the report of the medical officer, Mednipur Medical College and Hospital, that the victim was admitted to the hospital. The victim was brought dead to hospital at 12 noon on 20th of January 2021. Further, the postmortem report and the investigation by the police authority and the charge sheet submitted corroborates the case of the claimants regarding death of the victim due to accident. Learned trial judge has considered these issues and have come to a findings in this regard upon holding that the offending vehicle being number
WB 33D.
W
WB
33.
WB 33D stroke 6407.
6470.
No, just 6407.
70.
Okay. 6470 was liable. No, it is always the 6407.
No, in the claim petition,
In the issue also it is 6407.
Maladi.
Oh, right. 6470 was involved in the rash and negligent driving. Liable for the rash and negligent driving. Thus, there is no scope to interfere with the said findings. With regard to the consideration of the notional income, it is the case of the claimants that the victim used to earn rupees 21,000 per month. Stop. Although a certificate issued by one of the person claiming himself to be the owner of the said transport was filed, but the same was not proved before the court. Stop. In absence of the relevant documents with regard to proof of income, the learned trial judge, considering the nature of occupation, the members of the family came to the findings and observed that the dependents that to run a family at least 3 rupees 300 per day income is necessary, and there was no evidence that the parents or the wife of the deceased used to earn any money. Stop. As the driving license of the victim was proved and exhibited, it corroborates the case of the claimants that the victim was a driver, and considering the nature of occupation and the income required to maintain a family, the learned trial judge did not commit any error in proceeding with the notional income of rupees 10,000 per month. With regard to the submission that the vehicle was not covered by the permit, although the insurance company filed a written statement in that regard, but no evidence was adduced by examining either the vehicle owner, either the driver or the Motor Vehicles Authority or the IO to ascertain as to whether the vehicle was covered by the permit. In the facts and circumstances, it cannot be held that the vehicle was not, that there was a violation of the policy of insurance. In the facts and circumstances, this court is of the view that the learned trial judge, upon considering the necessary factors, passed just and reasonable compensation in favor of the claimants, respondent number 1 to 5. Hence, there is no scope to interfere. Thus, this appeal fails and the same is dismissed. The order, judgment and award passed by the learned additional district judge, first track second court Paschim Medinipur, in motor accident claim case number 206 of 2021, on 6th day of March 2024 is affirmed.
Lordship, we have already deposited the awarded,
The awarded sum, if already deposited, may be released in
With-
favor of
the
the
interest it is also.
in favor of the respondents number 1 to 5 claimants upon compliance of necessary formalities.
My lord, kindly add, my lord, the deposited amount with accrued interest.
Whatever is deposited.
No, my lord, my lord, one thing, my lord, we
Have you deposited with the interest?
With interest it was
Yes,
deposited,
but
Lordship.
hereafter, my lord, the Honorable Justice Ananda Bandyopadhyay says that the Registrar General shall invest the amount deposited. So, my lord,
We withdraw the awarded sum along with accrued interest, if any. Along with accrued interest, if any.
চালানের ছবি তুলে নিয়েছি।
হ্যাঁ, ঠিক আছে।
আমাকে বললে আমি সব
Yes, this one.
দরকার আমার শরীর ভালো নেই।
I'm getting.
Yes, call the 12 p.m. fixed matter.
Well, Passover matter is there. Well, other side has come. It is a very
Yes.
short matter. Well, only interest.
So there is a fixed matter at 12 p.m.
It is also fixed. It was fixed on 10:30.
Okay, Passover, both sides are present.
Yes, yes.
Your Lordship, the sole ground. Lordship, the sole ground of appeal in this case by the insurance company in respect to the interest component and nothing else.
Let me see. You have also filed a cross objection.
Yes, my lord. But it is also very small, my lord. The salary he was a police personnel who died, and my lord, this police personnel get 13 months salary for service of 12 months because of they do not get any leave.
So
That has not been considered.
so
This
did you
is all.
state that in your claim petition?
Yes,
that
my
you-
lord. Yes, my lord. And that has been proved. That is not directly stated in the claim application, my
No,
lord.
no,
but
it has to be
that has
stated
been
in the.
proved, my lord. That has been.
No. It should be a specific case. Yes, we know that. But this has to be proved.
Yes,
It
that
to
has
be
been proved,
stated.
my lord. The police personnel appeared, they produced documents that has been exhibited, but in spite of that, the learned tribunal has not considered it.
So was this point argued? Okay, let me see. Okay, your
Yes, that has
statement
been-
is
The interest component is 7.5%. Kindly come to the ordering, the paper book,
let me-
running
which
page, running page, Lordship, page 74. Running page 74, it's volume 2, your Lordship.
Volume 274, no? Volume 1 is 74.
Volume 1,
Yes.
Volume 174. Volume 1, volume 174.
64,46,000. Anyway, that direction was issued.
Yes, and along with 7.5% per annum.
Okay.
We are considering that it
what
should
was the income, annual income considered?
Yes, Your Lordship, kindly come to the page 70.
72.
Yeah, 72. 72, the annual income, 70, not 72.
Yes, yes.
Yes, 72, the annual income per month has been considered as 31,061.
That is
Where is that evidence that
Lordship, kindly come to
no,
page
that
70.
13 months salary
Yes,
was
ma'am.
given? That should
I'm
come-
coming. I'm coming.
Lordship,
That is
before
exhibit number 25 and 26, my lord.
26.
26. Page number is
150.
22, 23, 24, 26. Well, 156, my lord. 156.
Page
156. 155 is the salary on the basis of which that 31,000 has been considered. And
regarding the evidence that 13 months salary he used to get. What is your statement?
Your Lordship, Your Lordship, have to consider page 70.
Page
Volume
70.
1, page 70. What has been argued before the court that I want to show.
Yes.
Page 70, para 43.7.
Yes.
During his examination in chief, the PW4 mentioned that deceased Mamta Boshak was employed in the police department. During his cross-examination, the PW4 had deposed that the gross salary of the Mamta Boshak in February 2021 was rupees 31,061 and net salary was rupees 20,891, and that rupees 150 was deducted as P-tax. Although the payslip of the victim for the month of February 2021 was produced in evidence, it was marked as X1 for identification. But on bare perusal of such document, which is a computer-generated slip issued by the system not requiring any signature, it appears that the evidence of the PW4 has regard the gross salary of the deceased was truthful. OP number 2 could not demolish the evidence of the same, the witness in this regard. So, Your Lordship, here my learned friend was pointing out, was showing Your Lordship a document of 2020, wherein your 2021, there's another pay slip which the learned court has considered and has awarded the amount.
Payslip is for a particular month.
Yes, Your Lordship.
99% of the cases, annual income is to be considered. That
Yes,
is
Your Lordship.
multiplied by 12.
Yes, yes.
But in case of police persons, 13-month salary, on the basis of 13-month salary, annual income is certain. Okay. So, where is that evidence that he used to get salary for 13 months? That should come in the evidence.
That has not come, but they have produced the certificate and that has been
Where is
exhibited.
the certificate?
Page number 156, my lord.
156. Paper book number 2, volume
Paper
2.
book now, volume 2. Volume 2, my lord. Pay slip, my lord. And in the bottom portion, just before that Excel sheet, cash compensation pay bracket in brackets 13 months year 2020.
It's a compensation, Your Lordship.
And
It's
my lord,
not the salary. It's a compensation.
No, this is basic pay, DLNs, everything. So income tax, we did not come under the category of income tax.
They have not filed. They have not filed any
Anyway,
income.
this question was not put by the insurance company also.
We have put, but he's a government servant that we cannot, though he
It has
may,
to be deducted from the tax deducted at source.
yes,
It has to be deducted.
there is a tax deduction as well. A small amount has been deducted, Your Lordship. But
No,
that,
here it is, you see. Ultimately, this 1,59,960.
that is the cumulative, my lord. Amount is 48,300.
48,000?
300. 48,300.
That is monthly.
monthly.
No,
Total.
How it can be total?
This is the earning.
It cannot be total, Your Lordship.
And my lord, grand total
48,160
48,000.
net pay.
Yes, yes.
150.
Net pay
Net pay
48,160.
Yes.
Your Lordship, this is,
So the court proceeded on which 48,000 is
That
the
has not been considered. Instead, my lord,
question is, let us see.
if your lordship kindly come to page number 155
Yes.
in this chart, my lord, for month February gross, that is 31,061. 31,061.
February 2021.
February 2021. Yes. Financial year 2021.
Net comes to 20,891.
yes, that has been observed by in the page 70.
Out of which, my lord, only this P tax is deductible.
120 something.
120 is
So
deductible.
how much
Nothing.
so 20,891 is the salary of February. Okay.
No, my lord. Salary of February was
February,
say
not
31,016.
No, no.
last.
That is page 155.
Page 155. 31,061. And that has been considered.
No, no, just a minute. No, I find You see, basic pay, it is 28,700, February 2021.
Yes.
Three lakh 41,200. $861 is the DNS allowance. There are other allowances also.
Yes.
So 20,891 comes.
Yes, your lordship, and with the gross that is the net salary. The gross salary is 31,061, which the learned court has considered. He has taken the gross salary.
31,061 is the
Gross salary.
gross salary.
So higher end has considered. Higher end has been considered. So there is no.
That is the monthly salary.
Monthly salary. That is the highest salary which has got, and the date of the deceased died. This is the last drawn salary, your lordship, as the deceased died on
in March, in the next month, but before with completing.
Yes, before completing the month of March.
61.
So this is the last drawn salary.
Very well. Let us consider it to be 31,000 itself.
Yes, 31,000.
31,061, and my lord.
Very well. Let it be 31,000.
And my lord,
so how much it should be? 13 months salary.
Another 13 months salary, 13th month's salary, my lord.
That is.
That is to be. That
means no. Why do you get that evidence? The 13 month salary.
That is
my lord. This is written here. This in page number 156, my lord.
156.
Cash compensation pay.
Okay, that is given in terms of cash compensation.
Yes.
In the year
2020.
That means which part of the year it was given?
2020.
Not it has been given
48,160.
Yes, 48,160. That enhancement.
That is not a 13-month salary, but it's a cash compensation.
Cash compensation. Yes. That cannot be considered because on
cash compensation.
The victim died on 21.
That is, you see, as because they do not get the leave and all these things,
they may get a compensation.
That
but
compensation
but
is
that
given.
has not been given for the year of 2021. This is a document of 2020. The deceased died on 2021. On 2021, this is the document.
No. That means had he been alive, he would have got that.
Yes.
Had he been alive.
Alive.
Yes.
Your question, but that has not been argued in the lower court.
No, my lord, we did it here.
You see, that document is available once in a year. So maybe it is given usually if it is the usual practice to give it in the month of before puja, it will be given previous year.
I bow down.
So let us consider, you see, as 31,000. And how much was there?
48,000.
Your lordship
48,000.
No, that means you see 12. So 31,000 into
13.
31,000 into 12.
Into 12, yes.
That has been considered.
That calculation has been made, man.
That is not given, your lordship.
And if your lordship kindly come to page
Anyway,
number
3,72,000.
Yes, that has been given. More than that has been given, your lordship.
Anyway, I shall consider 3,72,000.
Yes, your lordship.
And so that was
if your lordship kindly come to page number 72, a clear calculation has been made by this learned tribunal. Volume number 1, page 72.
Volume number 1, page 72.
Page 72, my lord.
Yes.
Income per month 31,061. As such, annual income is into 12. Add future prospect 50% as you as a government employee and be 30 years of age at the time of death. And my lord, total income comes as 5 in addition future prospect 5,59,098 less deduction 1/3. That means total income after
So
deduction.
instead of considering that 48,000 cash compensation, let us take another month's salary.
Another month's salary, if you
so then it will go to 13.
Yes.
Another month's salary also.
So
but
that
we have
31,000.
31,000 because
instead of 48,000,
it will come 31,000.
Let us take 1 month salary as 31,000.
31,000. But then that you have to divide it by 13 then.
Yes. Anyway, that
into
will, because that is given for 1 month.
1 month only.
or 30,000, whatever it is.
Yes.
And your lordship, one thing is that this whatever they are stating today before lordship, that has never been their defense or never been adjudicated before the lower court. The 13-month salary, they should have pointed out this thing before the landed lower court below. So calculate the compensation. Though the document was
If
there,
you're-
they have never pointed out
Yes.
this thing. And this thing, if at all they have considered, this should have been in the at the time of passing the order, this should have been discussed. The lower court, what have discussed, have taken the highest possible income for it. They have not taken the net salary, or they have taken the gross salary. So in my opinion,
It comes,
have
you see,
cross-examined it.
about 4,03,000. If it is proceeded with 13 months salary, very well.
Yes.
That cash compensation is given. It must be given for every year.
maybe we take it that it should be another month.
Another month. So
another month
it comes to 4,03,000.
4,03,000. Then it has to be divided by 13.
Yes. No. Question is 1/3 has to be deducted.
1/3 has to be deducted. So
And
your
future
lordship,
prospect
this cannot be
50%.
the calculation which has been given in page 72. My learned senior friend cannot overcome that hurdle anymore, because the maximum has already been given. How much could be increased further? When we are not
No,
disputing.
what is the ground for not taking that into consideration? Cash
If your lordship
compensation.
kindly take that as well. I'm not disputing
No,
that.
so suppose I take that.
That you have to increase
So how
another
how much? So 1/3 should be deducted.
your lordship
Plus
take
50%,
31.
my lord, 50%, my lord. Future prospect.
What was his age?
30.
30 years.
17 multiplier. That is not disputed.
Okay, future prospect 6 lakh. So if 1/3 goes, it will go to 4 lakh.
Yes.
It will come to 4 lakh. This is the approximate round figure.
Round
I'm
figure.
just considering instead of 4,03,000, just simplicity 4 lakh. 1/3 goes at 50%, 6 lakh. Then 1/3 goes. Then it is 4 lakh.
Yes.
It will be around 3,72,000. Around.
4 lakhs and my lord into multiplier 17. Now, my lord, loss of estate and funeral expense and loss of consortium.
That means 4 lakh is the annual income.
Annual income.
My submission will be around 3,72,000, because 3,72,732 will be the odd amount. It will be 73,000.
4 lakh was, yes. So how much was, what was the multiplier applied?
17.
17, your lordship. So 3 lakh, if you take it round figure 3,73,000 also, it would be around 60.
Then 30. What is the 13-month salary?
If you take your lordship,
salary.
Your lordship, then that has to be divided by 13. That is, we cannot divide it by 12 then. If we consider the 13-month salary as well, we take your lordship,
It's better go by the 12-month salary. Okay. 12-month salary means per month, because every month he is getting salary up to 12 months.
Yes.
For 1 month, he is getting the cash compensation.
Cash
Okay.
compensation.
Instead of considering the cash compensation of 48,000, let us consider the average cash compensation of the 30,000.
Your lordship,
How much it comes yearly
one
income?
thing has to be taken into account, your lordship. The cash compensation cannot be the same for every month, because if you take the cash
Not
compensation
month.
Every
year.
every year.
Yeah, he
Yes,
addressed
lordship, I
to
agree.
get that.
I bow
Yeah.
down. Every year.
So it comes within an yearly income.
Yes, it is.
Apart from this annual salary, he gets this compensation every year. So that annual income will increase.
Yes, your lordship, I bow down. But for the cash compensation is not the same, because if your lordship take 2021 pay.
No, I'm not taking. You see, that is why instead of 48,000, I'm just taking it 30,000.
13.
Not even 31,000. Simplicity taking 30,000.
If lordship take it 40 to from 13 for the 30,000 as a year, then my suggestion is that whether the cash compensation is regularly been given or not, that point has to be taken into evidence. We have not got that opportunity. It should be sent back to the learned lower court below for that component. to be decided.
When-
Whether, only on this
that-
sole point, whether the cash compensation is regularly given to a policeman.
Your lordship,
If it's
kindly,
so, it should be awarded on that basis.
your
And we
lordship,
will bow down.
kindly come to the evidence of PW3.
So total compensation comes to 68 lakh. No, 68 lakh? Oh, that is. Then again this 80 and 30. 68 lakh 70,000. Yes, which page?
If your lordship kindly come to page number 38, my lord, PW4. Volume 1.
Yes.
I am posted now in RO office of Southeast Division of Kolkata Police. I have been authorized as per someone of this such and such. Next page, my lord. As per summon of the court, I have today provided the certified true copies of service roll salary statement for the period March 20 to February 21 pay slip for the 52-day leave compensatory pay, a certificate regarding last working day, and one GD entry bearing number such and such, all in connection with the service of Mamata Bosak employed in our department. Those documents have been certified to be true
52
copy.
day for
and-
leave compensatory pay.
That is
Leave compensatory pay, your lordship.
52 days leave compensatory pay.
So that
So
is
that came to 48,000.
That came to 48,000.
And
Now
my lord,
that has to be taken into account on the month of 21, on the year of 21.
leave what does it mean, leave compensatory pay? It means, my lord, that he has no leave has been provided to her, and that is why
If
as
suppose
a
he has taken 51,
compensation,
if suppose he has taken 51 days of leave,
as
then
they have not taken any leave.
how could you
He-
say
he
that?
was entitled. He
How
was
could you say that?
entitled, but in spite of that, nevertheless, that was not provided to her.
If it
That was
if,
not availed to her. That is why, as a compensation amount, my lord, that has been given
if
to
this
her.
is the point, your lordship, then this
So
should
this is
be
called leave
this
compensation.
issue should be sent back to the learned lower court
And
for
my lord,
the
what they have
proper
got, they
adjudication.
have got enough opportunity to cross-examine on this point.
Who
But
will
they have not.
this is the how could
They have not.
the
They have
police
only,
authority has not submitted
endorsed-
how many days leave
My
they
lord,
have taken.
my lord, one thing, my lord, in the
Leave
bottom
has not-
portion, these are the said 5 documents. They have endorsed with objection. My lord, kindly see, my lord, with objection. That means they got opportunity to testify these documents.
You have also got opportunity to prove it beyond doubt.
Proved.
No, you have,
We
there,
have
there-
proved.
there's an objection to it. And your lordship, they have not proved that there is no leave. Whether he has taken 60 days leave, whether he has not taken 60 days leave, that has never been proved.
It is
How
clear-
could I,
it
how
is
you
clear
show
from
one
the face
document,
of the
you
document.
say you show before the lordship today
Document says-
one document which says that he has not taken a 51 days leave for the year of 21. If one document has been proved today, I will bow down and I will settle whatever it is.
The statement itself shows
That is for 2020. That is for 2020.
Yes,
And that
but
amount
that
you have
has-
already got.
that has-
21 for the year of 21, you have not produced any document to show that how much leave he has taken or how much leave he has not taken. For that, then only we can quantify that is whether he or she is
I am
entitled.
leaving it upon your lordship. My lord.
Yes,
My learned friend
my your lordship, for doing justice,
Page
my only submission is this issue to be kept open and sent to the learned lower court only
My
to
lord.
this issue and to determine ki
After the admitted compensation is paid, you pay the admitted compensation, then that.
yes, your lordship, I am ready. I'm ready for that. I'm ready for that. I'm ready for that as well, your lordship.
Then-
For the admitted compensation, I'm ready to pay them. That has already been secured with London Registrar General. I bow down and I say that this should be given to them with an interest of 6%. That's my only submission. There, my contention is 7.5% interest has been given. They are entitled to 6% interest.
And you have to consider what evidence is there with regard to that compensation, and with regard to whether it's a regular income every year or not. What is the evidence with regard to that, and then arrive at a just and reasonable compensation.
Yes, your lordship.
And yes, that interest issue definitely.
Yes, sir. If your lordship wants that they should be getting the money, I am ready that they should get the money, but this issue needs to be adjudicated. before before we should also.
Let me see if
What
there are sufficient
prevented
materials
them?
are there.
What prevented them to
If
raise
there
the
is no
issue in the
material,
lower
then
court,
it has to be sent back.
in the trial
Yes,
court?
Your Lordship.
Yes, record an order.
Well, my lord, my client is suffering, my lord.
Learned
They are almost
advocate
starving.
for the parties are present. Hard learned advocates. Hearing is concluded. Let this matter appear for judgment on 11/2/2026.
Deeply obliged, my lord. Well, I have prepared one calculation sheet, my lord. May I place it?
Yes, yes, yes. এর মধ্যে ঢুকিয়ে দেবেন
11th, my lord.
আচ্ছা এইটা এইটা যে ইয়েটা হয়ে গেছে না এটা একটু পাঠিয়ে দেবেন আচ্ছা এটার সাথেই থাকবে Yes, call the 12 p.m. fixed matter. Yes, let me proceed. Thereafter, I shall see.
My lord, I am for the appellant. It's a very small issue, my lord. এটা একবার দেবেন। And it's a very small issue. In this case, what happened? The case was ordered. That is fine, Your Honor. But in this case, what happened? Unmarried son has died, and father and mother were the dependent. And father and mother are the senior citizen, and their amount has been kept in FD. So only for that thing, my appellant has filed this appeal, Your Honor. So only that is the thing, Your Honor, nothing else. And regarding this thing, regarding FD part, I am filing one judgment. এটা নেবেন একটু। I'm supplying to the other side also.
Where is the order under appeal?
Your Honor, page number 37, my lord. Page number 37 of the claim application. Both are the senior citizen, that is father and mother, and the amount has been kept in FD. So only for this thing, they have filed the appeal. And Your Honor, my lord, kindly see the judgment which I have given right now. That is Madhya Pradesh High Court judgment, page number 2, my lord. I am reading it, Your Honor. On pursuit of the petitioner, it is clear that the deceased Neetu Patel is the daughter of the petitioner, and by the date of incident, that is on 17/1/18, the claimant are 45 and 44 years. Now they are nearer to 50 years and starts ailments and need to spend some money for their essential needs. Therefore, they filed the present petition for setting aside the condonation as stated above and directing the tribunal to release the amount which has been fixed in the nationalized bank. Admittedly, that the tribunal has no such jurisdiction in case where the claimants are major, who are none other than the parents of the deceased. This condition is incorporated by the tribunal in unwarranted and uncalled for in the eye of law. The claimants who are the parents of the deceased are nearer to the age of 50 years, have every right to utilize the amount in any manner as they like. My lord, now page number 6 of the judgment. Point number 9. A judgment of Honorable Apex Court in the case of H.S. Ahmed Hussain and another versus Irfan Ahmed, relevant para 8 read as follows. In the facts and circumstances of the present case, we are of the view that the amount of compensation awarded in favor of the mother should not be kept in fixed deposit in a nationalized bank. In the light of above said judgment, no restriction can be imposed on the right of an adult to claim compensation amount deposited in their name by the railways. In the facts and circumstances of the case, the amount of compensation awarded in favor of the parents of the deceased should not be kept in fixed deposit, and their deposit money need for them for the necessity. Therefore, the petition is allowed, and the petitioner in the present petition near about 50 years. Hence, the condition imposed in para 17 of the impugned judgment is unwarranted and uncalled for in the eye of law and is liable to be set aside. Only this thing, and one more thing. To be fair enough, I would like to say, my lord, kindly come to the judgment part, page number 41. Not page number 41, my lord, page number 37. 37, judgment part. To be fair enough, one thing is there, in this case, 8 lakh has been given, plus interest has been given. So as per Supreme Court judgment of Reena Devi, if the accident is before 2017, then maximum amount can be given 8 lakh. So in this case, 8 lakh plus interest has been given. So that should be modified. I have no issue regarding this thing. Because as per Reena Devi, before 2017, maximum amount can be given 8 lakh, my lord. So that should be modified. For that, I have no issue, my lord. If other side has no issue.
Yes, what do you say?
Practically, this is an unfortunate matter. That's why award which has been already been directed by the tribunal, that is 8 lakhs. We are not opposing to that. And till date, since this appeal was preferred, no money has been fixed in the fixed deposit. Money has not yet been released. Pursuant to your lordship's direction, we can release the money. And he is not asking for or pressing for any interest.
No, I am not pressing it.
No, what is there? Because 7x, what is there that will
That
My lord, money should be deposited with the High Court Registrar General because they have not obtained the money yet, Your Honor. And make it.
That is not released.
That should be deposited in the High Court Registrar.
Yes, record an order. Learned advocates for the parties are present. Hard learned advocates. This appeal is directed against the judgment and order dated 7/5/2018 passed by Learned Railway Claims Tribunal, Kolkata in claim application number O capital A within bracket I
2U.
আচ্ছা within
OA
bracket
2U.
2 small u মানে II হ্যাঁ বড় হাতের II small u stroke 0102 stroke 2011. The ground of challenge in this appeal is that the learned tribunal, while awarding the compensation along with interest, had directed the respondent railway authority to deposit 90% of the decretal amount of claimant, number 1 and 2 being the appellants herein, in a fixed deposit scheme in bank account near place of residence of the applicant stroke dependent, at least for a period of 3 years from the date of disbursement, after proper examination of the credentials with regard to identity of the decree holder and after being satisfied of their identity and relationship. Stop. It was further observed that the amount deposited in fixed deposit scheme shall not be prematurely withdrawn without the leave of this tribunal. Stop. It was also directed that both the claimants appellants must be present before the disbursing authority of the respondent railway. Upon perusal of the learned advocate for the appellant submits that the learned tribunal, without applying the mind, has directed deposit in the fixed deposits account. Learned advocate also relies upon an unreported decision of the Honorable Madhya Pradesh High Court in MISC petition number 1753 of 2022. Stop. The Honorable Court in the said decision was pleased to observe as follows. Set out para 6 and 7. ঠিক আছে? The Honorable Court further observed as follows. Set out para 9 and 10. Upon hearing the learned advocates for both the parties and upon considering the decision relied upon, this court is of the view that no ground is cited by the learned tribunal and no provisions in the statute is quoted as to why the compensation awarded to the claimants who are adult persons will not be handed over to them by either bank draft or account paid check. As the appellant's claimants are not minors, the direction ought to have been given to pay the appellant's claimants directly. Stop. Thus, the direction of the learned tribunal in depositing the compensation amount in fixed deposit scheme of a bank account cannot be sustained and the same is set aside. Stop. In the facts and circumstances, the award of compensation which was granted by the learned tribunal remains unaltered. The respondent, Union of India Railway Authority, is directed to deposit the compensation amount along with interest as directed by the learned tribunal before the Registrar General, High Court, Calcutta. Such deposit shall be made within 8 weeks from the date of communication of this order. Stop. Upon the deposit being made, the appellant claimants will be entitled to withdraw the sum upon compliance of all necessary formalities. This appeal is disposed.
My lord, one more thing, my judgment should be in my name. In cause this is appearing as Rajendra Kumar Mittal, who was my father. So already fresh Wakalatnama has been filed, my lord.
No, the name is Bhuneshwar Thakur.
No, for applicant advocate should
Oh,
be
advocate's
my
name.
name. Advocate.
Let the name of the learned advocate for the appellant be recorded.
Sir, so far the interest is concerned, let it be in accordance with law.
No, interest, you see, that means you are holding whatever is the interest till
That's
date.
right, but above 1 lakh, they are not entitled to.
No.
As
1
per
lakh
the
is the
latest-
principal amount. 1 lakh is the principal amount. So definitely they are entitled to interest because the amount is still with you. You have, because he could not utilize that amount. Okay. So that interest has to be awarded.
And my lord, one more thing, in cause list it is appearing Union of India Eastern Railway. It should be Southeastern Railway, not Eastern. It is Southeastern Railway, my
See
lord.
the,
In cause
let
list it is
the-
Eastern Railway, my lord.
let necessary rectification be also made in the cost title.
Well, one indulgence I pray, my lord. Regarding my lord, the previous matter, your lordship will find that 52 days salary, 52 days leave compensation has been given. 52 days means in a year there are 52 Sundays, my lord. My client has
Very well, if you want to submit written notes of arguments, have copy upon the other side. If you want to argue again.
This is the
Very well, I shall
meaning of
consider.
52, man.
I shall
This is
consider
the meaning of 52 days. They are saying that every year 52 days will not come because every year there are 52 Sundays. And that is why they are not getting the 50 Sundays.
Anyway, that will be considered.
22, my lord, I am appearing. Sorry, I'm appearing on behalf of the respondent insurance company. And Mr. Niranjan Maiti is appearing on behalf of the appellant.
What application is to be disposed of?
Application, all are his application. My lord had granted me leave to file my opposition. I have given him a copy and I have spoken to him in the morning, my lord. He is out of station, but I had he had requested me to give my opposition and let my lord fix a date.
Okay, let it be not this week.
Not this week, no, my lord. Then my lord will kindly keep it after 17th because he'll be coming back after around 17th.
Record an order.
Maybe.
Learned advocate for the respondent is present. Let this matter appear on 18th to 2026.
May I give my opposition, my
The
lord?
affidavit in opposition filed by the respondent be kept with the record.
My lord, grateful, my lord. 18th of Feb, my lord. Grateful.
23. In this matter, my lord, I am appearing for the Union of India. Respondent.
Petition. Appearing petition.
Yes, what is this application?
My lord, I am filing affidavit in opposition in connection with Can 2. In connection with Can 2.
My lord, this is similar to item number 2, my lord, which my lord has been just now pleased to dispose, my lord.
Item number? No, this is application. Application for.
My lord, this is an application for taking subsequent event, my lord, because this is that matter where, my lord, the claim application, there are certain restrictions imposed upon the claimants to dispose of the claim, to withdraw the claim application, to award that amount.
So is that order under challenge?
That order is under challenge. Those
Paper books
conditions
are
are
filed.
paper books are not filed, my lord.
Let the paper books be filed.
Paper books filed, my lord, but let this application then
Let it be a part of the paper book.
let it be part of
My
the
lord,
paper.
may I be permitted to submit, my lord?
Yes,
In fact, this appeal is not maintainable.
yes.
Kindly have a look at section 46 of the Railway Act. He had to pay for execution of the order, and that is the legal provision. Instead of preferring execution before the learned civil court.
No, but are you aggrieved by the judgment and award of the tribunal?
I am aggrieved by the operative part of the tribunal, where tribunal has imposed certain restrictions as to the withdrawal of the money.
In fact,
And my lord, this similar question came before this
Okay,
one.
file paper books.
My lord, in fact, my lord, kindly consider my submission.
Yes.
My lord, the requisite documents that are required to settle the payment has not been submitted, and for which reminder was
He's challenging the
no
order.
reminder was given from the part of the Union of India, so that the claim can be settled. And
Do you have a copy?
yes,
Where is those
no,
copies?
in the affidavit in opposition, I have stated, my lord, I have annexed the document.
Okay, let me see the affidavit in opposition. So you want to, if there is an opportunity to settle the claim, you appear before the authority.
No, it cannot be, because my lord, here is a disputed question of fact, my lord. Because
No, what is the notice? You see,
we have given the complied, my lord. There was no response, my lord. The submission.
Your learned friend is talking about a notice with regard to the appearance and settlement of the
My lord,
matter.
no, my lord, perhaps, my lord, perhaps.
My lord, kindly have a
Affidavit in opposition to din to.
kindly have a look at page 8 of my affidavit in opposition. Page 8.
Lagi. Page 8. Yes.
Subject, my lord, 26th of April 2019. All these documents were not submitted. Subsequently, another reminder was given, and till date have not been given all the documents for which the claim cannot be settled.
My lord,
in fact, the appeal is not at all maintainable, my lord. Instead of
What is your reply to this
My lord.
opposition? What is your reply? Because they have issued this notice.
My lord, this notice, my lord, this notice I have denied. In reply, I am showing your lordship, my lord. This notice, receipt of this notice, I have I have denied, and my lord, as regards page 9 is an afterthought. Page 9 is an afterthought, because after receiving this notice, when they have realized that they might have to pay payment, they certainly wake up from their slumber and came before this honorable court and started making abrupt, random and desperate false submission which are not factually correct.
Page 9, you see. Page 9, according to them, no. Question is, are you accepting the judgment of the tribunal or you are challenging?
I am accepting as regards the quantum. I am challenging as regards the condition imposed by the learned tribunal.
Okay, let the paper books be filed. Record and order.
My lord, kindly give the direction to submit the record, my lord. Then it will be palpably clear to your lordship.
Let it be part of the paper book. Learned advocates for the parties are present. Let the affidavit in opposition and affidavit in reply be filed to the application. Can 2 of 2023 be kept with the record? The learned advocate for the appellant is requested to file the paper books within a period of 4 weeks. Trial court records have come.
Trial court records are not necessary. I have entire record with me.
Okay, within a period of 4 weeks, the copies of the applications and affidavits be made a part, and all relevant documents should be made part of the paper books. All relevant documents should be made part of the paper books. Liberty to mention after 4
My lord,
weeks.
paper book filing, my lord, I have all the documents. My lord, kindly fix the date, my lord. These can be very short matter.
I am adjourning it for 4 weeks. Mention after 4 weeks if it is ready.
My lord, in fact, my lord, this matter is covered by the judgment of the Honorable Supreme Court. Honorable Supreme, and I am placing reliance upon a judgment of.
Let him come ready.
My lord, if at the this can also be disposed at the application stage, my lord. Kindly fix the application under the heading application. At the
Okay.
application stage, this
No,
can be.
question is, you see, let the documents be considered. It's an old matter, all because these applications you want disposal. So your learned friend has filed an opposition to this. So let it be part
My
of
lord,
the
application and along, my lord, if this application is disposed, my lord, the appeal will be automatically disposed, my lord. That's why without filing.
better you come with the paper books. Come with relevant decisions also.
My lord, then my lord, 3 copies, my lord. 3 copies,
Yes,
3
yes,
copies.
File sufficient number of copies.
Sufficient, no, my lord, 3 copies. Otherwise, it will be 8 copies, my lord. It will be infructuous, my lord. Kindly make it 3 copies.
Okay, 3 copies.
And a copy is to be served upon me.
And a copy be served in advance.
Now 24. Lord, I am appealing for the state respondents.
Yes, who is appearing for the appellant? Item 24.
For the state
Lord,
respondents.
we are here for the all appellants. We're praying for, I am praying for my, on behalf of my senior, not today.
Okay. Not today.
Obliged.
Number 25.
Lord, item number 25. My lord will kindly have a look at this order. 2 analogous matters my lord has fixed on 17th February at
Who is
10:30.
for the respondent insurance company?
No, my lord.
Appellant insurance company?
Yes, my lord, Mr. Devanjan Mukherjee is appearing on behalf of the insurance company. My lord, kindly seize this order. My lord can fix this matter on 10:30.
Yes, let this matter, record an order, let this matter appear along with COT.
No, along with my lord FMA 192 of 2021.
Along with FMA 192 of 2021 and
FMA 396 of 2022.
And FMA 396 of 2022 on
17th February 2026.
On 17/2/2026
at 10:30 AM.
Okay, at 10:30 AM.
Deeply obliged, my lord. 17ই ফেব্রুয়ারি 2026। My lord, I'm praying for not today.
26, my lord. Mr. Amit Rai
Okay,
just
not
proposed-
today.
Not today, my lord.
Well, 27, I beg to appear on behalf of the applicant. Well,
You are the appellant?
yes, my lord.
What is this application for?
But the application is, my lord, for stay of the award passed by, my lord, the learned trial judge, additional district judge, fast track court, Howrah.
Who is for the respondent?
My lord, this is appearing first time, my lord. I am, my lord, praying for a stay of the award.
Let me
Limited.
see.
Yes, my lord.
No, you are for the, not for the insurance company?
No, my lord, I am the owner of the offending vehicle.
Very well. You are the owner of the offending vehicle. Have you deposited the awarded sum?
Yes, my lord. No, what happened, my lord? I will.
No, unless you deposit the awarded sum, no. Have you
My lord,
deposited
here
the
the-
statutory amount?
Yes,
25,000?
statutory money has been paid, my lord.
So
Another-
the
my lord-
award is passed against you?
Yes. Before, my lord, filing the claim petition before the trial court, pursuant to a direction by the Honorable High Court, I have paid 4 lakhs rupees with the trial court. That has not been taken into consideration at the time of passing this award. my
Okay,
lord.
statutory amount you have deposited.
Yes, that I have deposited.
Yes, give the slip.
Yes. Apart from that, my lord would kindly see that the claim petition was filed in the year 2022. However, in the year 2019, I have paid 4 lakhs rupees with the, my lord, the court below.
Very well, you just served.
Yes,
Yes,
my lord.
record an order. Learned advocate for the appellant is present. Appellant is present. As the appellant has deposited the statutory amount of rupees 25,000, there shall be an interim order of stay of the judgment and award passed by learned. Judgment and award dated 25/8/2025. 25/8/2025, passed by learned additional district judge, first track third court Howrah, in MSCC case number 173 of 2022. 173 of 2022 for a period of 5 weeks. Stop. the appellant shall deposit the entire awarded sum within this period of 5 weeks, along with interest as directed by the learned trial judge. Stop. In the event such deposit is made within the period of 5 weeks, the ad interim order shall continue till disposal of the application. Let service of notice be effected upon all the respondents within 1 week, and the affidavit of service be filed. The liberty to mention.
Well, only one issue, my lord. My lord has directed us to pay the entire decretal amount.
Yes.
But my lord, that has already been deposited. That is my case. That at the time of passing the award.
Anyway, you serve a copy. If
Yes,
you
my
can
lord.
satisfy.
But my lord, otherwise, if I do not deposit that money, this stay will be automatically vacated, my lord.
I have granted you 5 weeks time.
Well, my lord, within that
Even
time, I
if
will
you can-
serve and mention before your lordship, my lord.
Yes, please serve all.
Because my lord, that is my moot issue. That at the time of passing the order, interest has been imposed upon me on the finding that I have not made any endeavor to make the payment to the victim. However, the learned court was seasoned of the fact that before filing the application, 3 years prior to filing the application, my lord, I have paid 4 lakhs rupees with that court.
Anyway, that's a matter of to be decided
Yes, my
on
lord.
merits.
So
Okay.
that I will serve the copy and
Have a
come
copy, you
before
see,
you.
because
Because
we
my lord,
have to-
otherwise I will be double.
Because you see, no, unless you secure the amount, no stake.
But that is already secured, my lord. That is already secured by the direction of the Honorable High Court. What has happened, my lord? I tell you,
I shall see that you serve and come.
very well. I serve and mention, my lord.
Yes.
Because otherwise, my lord, I will be prejudiced because I have to deposit the money twice. From 2019, I have deposited that money.
Before the trial court.
Yes, that has not been taken care of. And that was order passed by the Honorable High Court. Kindly see my application, my lord.
I shall
Number
consider
28.
you serve and come. Okay.
Once, my lord, 28, my lord. Otherwise, my lord, I have to pay twice, my lord.
I have granted you stay for 5 weeks. You serve and
Before
come.
that, I will mention. Before that, I will mention.
Come with relevant documents.
Grateful, my lord. Grateful.
My lord, this is insurance appeal appearing for the first time. My lord, I was praying for interim stay. My lord, there is no delay in this case.
Yes. Yes. Yes.
My lord, the statutory amount made, my lord, deposited, and I was praying for interim
Yes,
stay.
record an order. Learned advocate for the appellant is present as the appellant insurance company. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 22nd day of September 2025, passed by learned additional district judge, 5th First Track Court, South 24 Parganas at Alipur, in MSC case number 31 of 2016 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial judge, excluding the statutory amount within the period of 5 weeks. In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General High Court Calcutta is requested to invest the amount deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Obliged to my lord.
You're 29. 29.
Yes, not today.
My lord, the advocate for the appellant is appearing virtually for item number 29.
Your Lordship, I am appearing for the appellant on behalf of I am appearing on behalf of the appellants.
And what is this can one
I am
for?
there, my lord, leading Mr. Sharma.
Your Lordship, can one is appearing.
My lord, this can is in the nature of an application under Order 41, Rule 27.
And can two?
That is the application. Then there is one application, I believe. Can do is Order 41, Rule 27.
And can one?
Is the main application
For stay?
in the appeal. No, I don't want to stay.
Okay.
I want
Your
to
Lordship, can one is my application for appropriate orders, Your Lordship.
Anyway, the appeal has to be heard out.
Can 2 is for Order 41, Rule 27.
Paper books have been prepared.
have been prepared.
The matter is ready for hearing.
File, yes. Only thing can do is the order 41 rule 27 application disclosing certain income.
It will be taken up along with this thing.
Yes.
But may I file my opposition, my lord, with regard to can 2?
But this is really.
This is a motor accident claim matter?
Yes, yes.
My lord,
Oh, I
certain-
thought,
this
because
is
he is appealing, I thought it's some other critical matter.
my lord, this is a very
No,
big
my lord.
matter, my lord, with a lot of money involved. So, my lord,
Oh, paper books, you see, usual
Paper
procedure
books.
is to file the paper book.
We have filed.
my lord, paper books.
Paper books have been
So let
filed.
the appeal be heard out.
Yes, my lord.
My lord, I need to file my opposition to that can 2, my lord.
I have
Additional-
only
additional-
disclosed. May I just
additional-
indicate before my learned senior friend commences his argument? May I
No,
just only.
are this application part of the, this thing, paper book?
No, application is not part of the paper.
So make it a part, make it a supplementary paper.
We
book,
can.
Okay.
But only thing, may I just give your lordship the contours of my application? In the, because this, the deceased had passed away prior to filing of the income tax returns for that year. So, my lord, in the, we had included by way of the order 41 rule 27 application, income tax returns of certain other firms from which the deceased had received, my lord, remuneration. To corroborate the entries made in the income tax returns filed post death. Because my lord, the income tax returns which we had relied upon, since it was filed post death.
Because you see, this is a matter with regard to income issue, okay?
Yes.
Not with regard to any other findings of facts. So let Mr. Singh file an.
That is why I'm giving income tax returns. Well, he cannot really oppose my income tax returns. The income tax.
File an opposition. How far? Or you can do one thing. You just incorporate it.
Kindly uses kindly
Supplementary-
coerce my learned senior friend not to use any opposition. Kindly coerce, my lord.
Let there be a supplementary paper book.
I will. That I will. That I will.
At
In
the
3
time
days.
of hearing of the appeal, I shall
Kindly
consider.
coerce my learned senior friend not to use any opposition.
Anyway, at the time of appeal, he can submit.
My lord, there are certain documents, my lord, what I understand now, certain documents have been, my lord, by way of 4127 are being, my lord, produced before your lordship.
Actually, Mr. Gupta is continuing his usual practice in other civil matters. In MSCC, this
But
is
this is
not
my
done.
first matter and the only.
No,
matter. I do
because
not know, my lord.
being expertise in the civil matters, he is following the due process under the code of
My lord,
civil procedure.
certain documents are sought to be incorporated, my lord, which were not a part of the code below.
Yes, that order
My lord,
41, rule 27.
I'm grateful to your
empowers the
lord.
court
I'm grateful to my
to
lord.
consider that.
My lord, so my lord, let me at least go through. If affidavit is required, I'll file. If not, I won't.
Yes, record an
An
order.
opportunity be given to him, my lord.
Kindly give
Garnet-
me 3 days time to file a supplementary paper book. Kindly please
Garnet
have any day next
advocates
week.
for the
submit the senior friends.
Parties are present, hard learned advocates, as Mr. Gupta intends to move this application can 1 of 2025 under order 41 rule 27 of the Code of Civil Procedure. Let the same said application be made a part of the supplementary paper book. Mr. Singh, learned advocate appearing for the respondent number 1 insurance company, may file an affidavit to the said application, which shall also be a part of the said paper book. Upon receiving the copy of the said application, opposition, the same should be incorporated in the supplementary paper book. Let this matter appear on 18/2/2026 under the heading to be mentioned. The affidavits must be made in the meantime.
My lord, I'm for respondent number 2 in this case. Your lordship will kindly make the.
Your lordship had indicated respondent 1 insurance company. It should be.
Number 2 insurance company.
No bless to your lordship.
In this matter, we are for the appellant.
Yes, what is this application?
Application lordship for stay. It was lordship till
Now, who is for the respondent?
we have served lordship pursuant to the division bench order. It was admitted and specific question was
The
formulated.
respondents have not entered appearance.
No, lordship. It was admitted on 9th of September. Thereafter, lordship directed to serve the copy of the application. Service has been effected, lordship.
To serve upon the trial court advocates.
Order of remand lordship, initially suit was decreed. Now learned first appellate court lordship remanded the matter before the trial court with a specific direction to the defendant to file an application for order 26 rule 9 and to decide the matter on the basis of the said report filed by the commissioner.
Yes, record an order. Learned advocate for the appellant is present. Let steps be taken by the appellant to cause service of notice upon the respondents through the department by filling up the requisite forms and documents. The learned advocate for the appellant is also requested to serve copy of the application upon the learned advocate appearing in the trial court.
So the appeal has already been disposed of.
Appeal?
The first appeal has already.
No,
been-
trial court. Trial court. It is
Trial
not.
court lordship, it is.
Yes,
before
I've
the
read
appearing
trial
of-
court.
Before the trial.
Let this matter appear.
In the meantime, lordship, the lower court record be called for.
Let this matter appear after 6 weeks. The trial court records be called for at the special messenger cost of the appellant. Stop. The paper books be filed by the appellant.
Informal paper.
Let the informal paper books be filed by the appellant on arrival of the trial court records. Let this matter appear after 6 weeks. Interim order granted earlier stands extended for a period of 8 weeks or till further orders, whichever is earlier.
Better lordship to lordship till disposal. Because appeal will be heard by your lordship on the.
Okay, for a period of 10 weeks.
My lord, I am appearing with the respondent claimant. Actually, my lord, can has been disposed of. And matter is ready for hearing. Very short question involved, my lord. This is a case under section 164. That is, my lord, 163A. And my lord, trial court allowed 5 lakhs. Insurance company.
So it is your appeal.
Yes. Yes.
So what is the ground of challenge?
Actually, no eyewitness, no vehicle number.
This is a case under section 163A. My lord,
164.
164. That means 163A.
Okay, let us consider the provisions. No, it was instituted under 163A.
Yes, 164. No fault liability, my lord. That is under no fault liability. Your lordship knows that.
The victim died during the corona period, madam. That's why, madam.
Yes, that is my lord, arising out of use of the vehicle. Accident took place, hospitalized. After
Oh,
that.
whether the involvement of the vehicle
Yes,
was in question. That
no,
is the
no, no.
question.
That has not been questioned.
So this is filed. The insurance case was filed in which year?
My lord, this case has been filed in the year 2021.
Okay, let this matter appear next week.
Yes, my lord. Kindly,
Yes.
my lord, at
Learned
10:30, my
advocate
lord.
for the parties are present. As this matter is ready for hearing and the paper books filed, let the matter appear for hearing on 12/2/2026 at 10:30 AM.
My lord. 12 তারিখ, হ্যাঁ।
My lord, this is the insurance appeal appearing for the first time before your lordship. My lord, the statutory deposit has been made as praying for interim stay, my lord. There is no delay in this appeal.
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 20th day of November 2025, passed by learned additional district judge, second court, Durgapur, Paschim Bardhaman, in MSC case number 193 of 2019 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within the period of 5 weeks. Stop. In the event within the period of shall deposit the entire awarded sum along with interest excluding the statutory amount within the period of 5 weeks. No. As directed by the learned trial court excluding statutory amount within the period of 5 weeks. In the event the entire awarded sum is deposited within the period of 5 weeks, the ad interim order of injunction shall continue till disposal of this application. The Registrar General, High Court Calcutta, is requested to deposit the awarded sum in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Grateful to my lord.
My lord, I have one request, my lord. This matter is fixed for today, but not listed. Getting stay 15th January 2026. Can one delay has been condoned, and I have served
The matter was due to appear today.
today.
Under what heading?
Can two.
So mention tomorrow. Tomorrow morning I shall see. Serve notice and mention tomorrow.
Now, serve notice already I have served, my lord.
So mention
Fixed
tomorrow. Okay. Mention tomorrow. Okay. I shall see that.
Your
If it is heading, if it is with regard to application, inform the other side and mention
I will
tomorrow.
get stay today, but not listed this matter.
Very well. I shall consider tomorrow. Serve notice, inform the other side, come tomorrow at 10:30. Yes.
Item number 34, it's long file matter, awaiting for some correction from lower court and need a direction from your lordship.
Anyway, I shall see tomorrow. I shall see. Oh, it is not yet admitted.
Not yet admitted.
Section 5 has to be disposed of.
No, not section 5. Only a correction is awaiting from the lower court. Correction was demanded. The lower court demands that they have sent it, but our department says that they haven't received.
The opposite parties have not entered appearance.
And the opposite party have not been served, sir.
Appeal is not yet admitted also.
No, not admitted.
এটাকে কালকে একটু টু বি মেনশনে দিয়ে দেবেন তো।
Item number 34.
For the appellant.
For the respondent.
Lordship, I have filed the paper book yesterday, but
Yes, copy of the paper book served.
I have served the copy.
I have received this paper book.
একটাই তো হবে
এতগুলো কেন দিয়েছে?
এতগুলো কেন একটাই তো হবে
সার্ভিস রেসপন্ডেন্ট অনেকগুলো আছে না, সেই জন্য বোধহয় করে দিয়েছে।
Yes, where is the order under appeal?
The 35 to 30.
order is
25.
25 to 34
25 to 34.
একানব্বই একটা ফাইল আছে একানব্বই
Yes, what is the wrong in this judgment?
Lordship, the suit property is admittedly a TICA-tenanted property.
Was the written statement filed and maintainability issue framed or simpliciter on the basis of plaint? This is done. No, question is, did you file written statement and the issue of maintainability framed that it is a TICA property?
No, no. My lord, the crux of the case is the respondent filed eviction.
Anyway, simpliciter on the basis of the plaint, this point of maintainability was taken that the suit is barred by law.
Order 7, Rule 11 was filed by them.
So it stated the maintainability. Order 7, Order 14.
Order 14, Rule 2.
So that was filed prior to the filing of the written statement.
Yes. And prior to that,
is it the plaintiff's case that it is a TICA property?
It is a TICA property.
It is a TICA. It is
admittedly
a TICA property.
We are not arguing on that. The main
whether West Bengal Premises
Tenancy Act will attract or not, this is the case.
That is the question of law.
That is the question of law. Yeah, which is the impugned judgment is saying about. Your Lordship, kindly come to page 29. The respondent filed a 7-2 application to deposit area rents. The court, which passed the dismissal of this suit on order basis of order 12 Rule 2.2, or earlier passed an order holding the defendants defaulter since 1981. This is the order.
No, the question is, while this application was
not filed earlier.
In the plaint, was that your case? The plaint itself?
The plaint itself. The plaint is as page 1 to 10.
Let us see the plaint. No, this is 6-1 application.
No, that is the plaint.
Okay, this is the plaint.
It is a 6-1 application.
Page 2.
This is page 1.
Page 1 of the paper book.
It starts from page 1 and the
that means you are a TICA tenant, the defendant is a Bharatia.
Bharatia. But they are default in payment from 1981.
So they were paying rent to the landlord. That is the TICA tenant.
TICA tenant. And exactly same judgment was there, which I am relying on. That is 2009 to Cal CLJ 596. It একটু দিয়ে দাও
596.
596. আমি কপি দিয়ে দিচ্ছি। Your Lordship, in this case, same 7-2 application was filed. It was held that the defendants are defaulter in payment of rent. And in this also they were defaulter in payment of rent from 1981. And this revisional application was rejected.
Now the question to be decided is merely the person is a Bharatia of a TICA property will oust the jurisdiction of the regular
civil
tenancy court or civil court, and the order and the power will be vested in the TICA court.
Yes, Your Lordship.
That is the pure question of law.
The pure question of law is this. The act came in commencement of this act is
2002. November 2002.
March 2003.
November 2002.
Your Lordship, I am handing over you. 1/3/2003. Commencement. Commencement published in Kolkata Gazette, extraordinary part 3, wide notification such and such, dated 22/11/2020, 2002 with effect from 1/3/2003. 1/3/2003. Even in the judgment by the learned First Civil Judge Junior Division, he himself, while passing the order, has mentioned.
Yes, where do we get that? It will come from 2003, section 1.
Section 1, commencement.
Yes.
With effect from 1/3/2003. And the defendant.
Yes, first day of March 2003.
And defendant is admittedly a defaulter from 1981. There was no existence of this law at that time, as per the order passed by the learned trial court, first court, junior division. Shialda.
Quickly comes to page 8 of the paper book. The plaint. Point number 6. The cause of action of the suit arose on first day of October 2005. I would like to rely upon one judgment of 2016 of this Honorable High Court. The citation is 2016, volume 3, CHN, page 1. Kindly comes to paragraph 10. This similar matter, the instant suit of eviction was filed sometime in the year 2005, like us. The West Bengal Tika Tenancy Act 2001 came into operation on 22nd November 2002. Paragraph 12, subsection 3 of section 8 of the said act provides that any dispute regarding payment of rent by Tika tenant to the state government or by a Bharatia to the Tika tenant or any case of eviction of Bharatia shall be disposed of by the controller in such manner as may be prescribed. And thereafter, paragraph 16 and 17, following this principle, we hold that the suit for eviction of a Bharatia by the Tika tenant will lie before the controller appointed under section 9 of the said act. As
Let
such,
us see this just a minute. This suit was instituted in which year?
2005.
2005.
2005. Yes. What is your decision of Justice Bhattacharya?
Your Lordship, the cause of action.
Let us
The-
see. No, maybe, but jurisdiction. Very well. Come to the jurisdiction. From your plaint, it is a suit of eviction of a Bharatiya. Okay.
Eviction of a Bharatiya.
So we consider this judgment. So if this judgment is applicable, then your suit is not maintainable.
Your Lordship, I have passed one, I have.
No, your judgment is with regard to the cause of action. But
No,
this-
their judgment is on cause of action.
their judgment is with regard to the jurisdiction of the court, maintainability. Please, you give him a copy.
I have only one copy.
I can read it.
You go through this and see how far.
That is also of Jyotirma, Honorable Justice
That's a
Jyotirma.
different issue, you
The-
see.
On the same issues.
No, this is the latest judgment of Justice Bhattacharya. Division bench judgment.
Yes. Your Lordship, in this case, he is not a defaulter from 1981. My plain case is he is a defaulter from March 1981, where there was no existence of this law.
The question is, you see, at this stage in the year 2005, you are seeking to evict a Thika tenant, a Bharatiya.
Bharatiya.
Whatever it is, during the existence of this statute, you want to evict this Bharatiya.
Bharatiya.
So save and accept this. As per the Act, there is no other provision. You see, this is the division bench judgment. This is binding upon this court. You see, consider paragraph, this section 8. You consider section 8, you consider the paragraph also.
Your Lordship, I am considering section 8(3) of the West Bengal Thika Tenancy
Yes.
Act.
What does it say? The division bench has interpreted section 8(3)
Yeah.
and held any eviction on any ground.
Any eviction on any ground.
Filed after the inception of this act.
Yes, pursuant to the framing of this statute. It is an admitted position, you file the suit pursuant to this statute. So, you are bound by it.
Your Lordship, in this case, this is the one scenario is different. The section 7(2) application was filed by the defendants. It was held by the learned trial judge. They are default in payment of rent from March 1981. The cause of action arose on 1981, not in 2005. It is a continuation of cause of action, not the cause of action arose in 2005 when the inception of the suit is there.
No,
It was the continuation of cause of action is from March 1981.
No, that was held in a different suit. In which suit it was?
This is the suit.
No, in
This
this
is
suit,
in the present suit. Your Lordship kindly comes to page 3 of the paper book. Page 3 of the paper book.
Yes.
The grounds of eviction.
Yes.
The para 3A. The opposite party is a habitual defaulter and has defaulted in payment of rent since March 1981.
Yes.
It is not that he has defaulted in payment of after the inception of this act. Prior to the inception of this act, there was a default. And any default prior to the inception of this statute, it will be governed in West Bengal Premises Tenancy Act. My contention is that it comes in effect in 1/3/2003. Prior to that, any default in payment will come into the West Bengal Premises Tenancy.
Maybe, but once you see the default is a continuing on, admitted position continuing one, although you have stated.
And
in paragraph 5, you see, paragraph 6, cause of action.
Your Lordship, cause of action is also that has been dealt in the judgment passed by the learned ADJ.
Cause of action is a bundle of facts.
Your Lordship.
Okay, now it is an admitted position. What is your ultimate object? Ultimate object is to evict him from the suit premises.
Your Lordship.
Okay, under the West Bengal premises.
And realize the rent.
Yes, and as well as you see,
In this provisions of law,
But-
there is no realization of rent prior to 2003.
Question is, you want an eviction decree, so.
Eviction of decree and default in payment also there.
But that is your mean profit, eviction and the mean profit.
Yes,
That
Your
is
Lordship.
eviction and the mean profit.
Your Lordship,
Now
kindly.
you see how far you see. If you say this judgment is not applicable to you, then you justify how it is not applicable
Because
to you.
in this case, there was no default in payment prior to the inception of this statute. In this case, this is a specific case that he is default in payment, and the learned trial court has upheld that he is default in payment, and 7-2 was passed against the defendant, and an area amount was fixed to deposit,
But that
and it was not challenged anywhere.
Interlocutory application does not alter the inherent power of the court. Cannot change the provisions of the statute.
That's for sure.
Maybe the court assumes jurisdiction, but when this point is taken before the court has to decide that.
But they have not preferred any revisional application.
Maybe in interlocutory matter, okay. Whatever order is passed, subsequently, if the issue of maintainability with regard to jurisdiction of the court is raised, earlier order will not affect the court in deciding the jurisdiction. It's a clear question of law.
Your Lordship, which I have supplied the copy of the judgment, which is also
That
passed
is
by,
cause of action, yes.
which is passed by the Honorable Justice Jyotirmoy Bhattacharya in 2009.
Let us see that.
The paragraph starts from
Give
before.
the copy. Give the copy.
I have given you a copy.
No. This is with regard to 2009.
That's what.
That is with regard to cause of action, where
Ranjit Sarkar versus Maluti Ghosh.
I have.
Ranjit Sarkar versus Maluti Ghosh. Before concluding, this court wants I'm reading this paragraph, Your Lordship. Before concluding, this court wants to keep in record, this court does not feel it necessary to consider the contention of Mr. Gupta regarding maintainability of instant suit before civil courts seriously, as the said point was neither raised by the petitioner before the learned trial judge, nor the same was decided by the learned trial judge. Though it is rightly pointed by Mr. Gupta, Section 8 of West Bengal Tika Tenancy Act provisions trials suit by controller appointed under the said act, but in view of repealing and saving clause in Section 27 of the act, which is the prima facie, does not create any bar maintaining the instant suit before the civil court, as the plaintiff's right to evict defendant has arisen under the Act of 1981 due to default committed by the defendant in paying rent during the time when 1981 was in operation.
So 1981 Act was in operation. This was
Operation at that time.
This suit was instituted in which year?
2005.
No, this suit which you are relying upon in 2009. The suit which was the subject matter of revisional application.
It was also instituted in 2005. The ejectment suit number is 399/2005. That is the first page. The CM suit was filed in 2005. Similar cause of action. 1981 was the default. Suit was filed in 2005. 7-2 was upheld. Defendant was declared as a defaulter. They came up before this revisional application to set aside the order of 7-2, but it was rejected, upholding that this suit can be contested in the civil suit, as the cause of action arose in 1981, when the earlier act was there of West Bengal Tika Tenancy Act. 1981 was there.
What was the subject matter there? The subject matter was
7-2 rejection.
okay. The relationship, 7-2 relationship between landlord and tenant.
The judgment handed over by the appellant, this is a latter judgment, but
Division bench judgment.
division bench judgment, but it is not mentioned that he was a defaulter. The defendant was a defaulter from 1981. This case and that case is a different one. And my judgment is exactly same to this instant appeal. He was also a defaulter from 1981, and the present appellant is also a defaulter in rent from 1981. When there was an act of 1981 prevailing there.
You see, this subsequent judgment of the division bench held with regard to the jurisdiction of the court, whether the court has jurisdiction or not.
Lordship, I'm still saying that jurisdiction after inception of 2003 judgment is not there with the civil court. I am on that the default in payment in 1981, the cause of actions arose in the year 1981 when there was another act in operation. And the case, same exactly identical case is there in Ranjit Sarkar versus Malti Ghosh, when the ejectment suit is filed in 2005, holding that the default in payment was of 1981, the suit can be exercised by the civil court. This is my submission. I rely upon this judgment.
That is Justice Bhattacharya's judgment, 2009.
Justice Jyotirmoy Bhattacharya judgment. Ranjit Sarkar versus Malti Ghosh.
Yes, you want to add anything?
No, Lordship, I just want to say that they have instituted the suit in 2005 after inception of the act, and they have stated in their plan that the cause of action arose on 1st October 2005. They have not stated that the cause of action arose in the year 1981. After
Yes.
24 years, they have instituted the suit.
I want to add
Upon this
add one thing.
2016.
In page 31, the cause of action, the judgment is Madan Lal Jalan versus Madan Lal, 49 Calcutta, CWN 357.
Regarding cause of action, okay.
Regarding cause of action,
you want to justify that
this
cause of action
arose earlier cannot be deemed that
But the suit is of 2003.
only the notice is the cause of action. It can't be treated as the notice is only the cause of action. Default in payment is also a cause of action that has been dealt. My ground of eviction is that he is a defaulter from March 1981.
If he is a defaulter, this matter should be adjudicated by the TICA controller.
Your Lordship, kindly comes to page 32, the operating portion of the judgment. 32.
Yes.
Which starts like from, it is submitted that by reason 2001 Act, the jurisdiction of civil court is taken away in view of Section 5 of the West Bengal Thika Tenancy Act 2001. The said act came into operation in 1st March 2003. Defendant was declared defaulter with effect from 1981. At that time, the said act of 2001 was not being taught upon. The said act has no retrospective effect and is prospective in operation. High Court, in the case of Sri Ranjit Sarkar Supra, which I have handed over, discussed the effect of provisions of Section 8 and 27 of the West Bengal Thika Tenancy Act 1981 and 2001 as to the instant appeal is concerned. And in view of the repealing and saving clause inserted in 27 of the Act 2001, this court is of a view that there is no bar in maintaining the instant suit before the civil court in view of the determination of the default was adjusted to have been committed by the defendant when Act of 1981 was in force. Therefore, the instant order and decree passed by the learned court below cannot sustain and required to be set aside.
So according to you, the judgment, division bench judgment presided by Justice Bhattacharya is not applicable to your case just for the reason?
Just for the reason that he is a defaulter in payment of rent from 1981 when there was a different act. This is for the 2001 Act, this judgment. After 2001, any case filed, it will be deemed to be filed before the Thika controller and it will be exercised.
Consider Section
It was
26.
instituted after 2001. In 2005, the suit was instituted.
Let us see Section 27.
27. With effect from commencement of this act, the Kolkata Thika and other tenancies and lands acquisitions regulation act 1981 shall stand repealed. Notwithstanding the repeal of the said act, such repeal shall not a affect a previous operation of the said act or anything duly done suffered thereunder. B affect any right, privilege, obligations or liability acquired, accrued or incurred under the said act. C affect any penalty, forfeiture or punishment incurred in respect of any offense committed against the said act. D affect any investigation, legal proceedings of remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture or punishment as aforesaid. And any such investigation, legal proceeding or remedy may be instituted, continued or enforced, and any such penalty, forfeiture and punishment may be imposed as if the act had not been passed. When there was 1981 Act and he defaulted in payment in 1981 Act, it will be presumed that that act will prevail. Delay in filing suit will not evaporate the wrongdoing of the defendant not paying the rent from 1981 since the day of institution of the said suit. And even though the learned trial judge, after hearing 7(2) application, hold that the defendants are default in payment of rent from 1981. that we are getting from page 29. Your Lordship, may I read?
Yes.
Page 29. The second paragraph. From the material of on record, it appears from the original suit was filed under section 6(1) of the West Bengal Premises Tenancy Act 1997, seeking for a eviction and recovery of khas possession and mean profit. Plaintiff was the owner and of the structure situated at such and such, under whom the predecessors of the defendant Rajendra Prasad Saw was inducted as tenant. After his death, the defendant became the tenant in respect of the structure by operation of law. After appearing in the suit, defendant filed petition under 7(2) of the West Bengal Premises Tenancy Act and the learned code
That's
below.
a different issue. You see, only thing is this, whether from the latest judgment, is there any classification, any exclusion that, yes, what his lordship held in this previous judgment, 2009. 2009, yes, to some extent there is an observation that, yes, this so far section 27 does not create any bar.
Your Lordship, this
Because you see, there you see, as the plaintiff's right to evict the defendant has arisen out of the Act of 1981. So, in your plaint, have you stated from when he committed
yes,
the default?
yes, Lordship. Kindly comes to page 3. Page 3. Paragraph 3. The opposite party has forfeited the statutory protection against the eviction and is liable to be evicted from the following grounds. A, the opposite party is a habitual defaulter and has defaulted in payment of rent since March 1981. Specifically mentioned the year and month from which when he is defaulted for payment of rent.
Only thing is this, whether by, you see, if this is simpliciter follow, you have no case. If the decision of the division bench is accepted in general, you don't have any case.
Yes, sir.
Irrespective of whenever the cause of action arose.
Your Lordship, I am on that. The cause of action arose in 1981 when there was another act, and I am relying on the judgment which is saying that 1981.
See, paragraph 14. We have no hesitation to hold that both the act and the rule. You see now, you just let us read paragraph 13 and 14.
13 and 14.
Yes. Necessary rule for dealing with eviction proceedings has also been framed under Rule 13 of West Bengal Thika Tenancy Rules 2004. Such rule was notified on 2nd November 2004. As such, we have no hesitation to hold that both the act and the rule were in operation at the time when the suit was filed. That means, in this case, whether the cause of action arose 1981 or 1982, there is no such observation. But when the act and the rule were in operation, that means after 2003.
After 2003.
Yes, the suit was filed. Similarly, is your case. Considering the aforesaid provision of the said act as well as the rule frame therein, we have no hesitation to hold that an eviction suit filed by the Thika tenant for evicting the Bharatiya lies before the controller appointed under section 9 of the said act. Such suit will not lie before the civil court, even though West Bengal Premises Tenancy Act provides for maintaining such suit before the civil court for simply reason that the West Bengal Thika Tenancy Acquisition and Regulation Act 2001 received the assent of the governor 22nd November subsequent to the grant of the West Bengal premises. As it came subsequently, this is also a special act. So that has to be considered. This judgment does not distinguish whether cause of action arose before or after. Earlier decision of the single bench
is based
gave
on
a-
based
gave a
on
distinction, but the latest one just makes no distinction, irrespective of cause of action arising prior to or after.
but this judgment is not dealt in this judgment.
Maybe this is a question of law. The division bench judgment is binding upon this court. Okay, hearing is concluded. Record and order. Learned advocates for the parties are present. Heard learned advocates. Do you want to file written notes of arguments?
Is it required?
Or whatever you have submitted is sufficient?
I will file my written notes.
Hearing of the arguments is concluded. However, learned advocates are granted opportunity to file written notes of arguments. Let this matter appear on 10/2/2026 at 4 p.m. for filing the written notes of arguments. So hearing is concluded.
Yes, sir.
You file that. Thereafter, the decision will be taken.
Much obliged.
ঠিক করে রেখে দেবেন।
My lord, I am praying for the court passer, Mr. Bhattacharya is on leg, my lord.
This is my term. I have to.
Okay,
I have to start.
You want to start?
Yes. Every day it is your everyday's game. Whenever you.
No, it is. Oh, you have not completed.
No, my lord, perhaps your lordships remember, whenever the matter was called on, a prayer for accommodation is sought for from every time.
Now it is on the verge of disposal.
Yeah, my lord, I thought, my lord, that on last occasion, my lord,
You have given incomplete decisions.
Yes,
Nothing.
Yes.
You give a a compiled portion, compiled one, so that it can be dealt with. You have made your arguments. Now you give your written notes along with compilation.
I have already handed over written notes, but my lord,
No, but on the last occasion you are just mentioning so and so. No side.
Yes.
Citation is there, man.
On that day, I submitted for your lordship that I am not relying on those because all are same.
Whatever
all
it
are
is, you
same.
submit
But
your
today,
written
my
notes
lord,
along with your compilation.
yes, my lord, today, my lord, I am relying only one judgment. I will conclude my argument. Only one.
You have to file your written notes.
Written notes I have already given.
Oh, so compilation.
Yes, if required, my lord, I will make a Xerox of it and hand it over.
That is only one decision.
Only one decision and last.
In the top of the sheet, whether it is submitted by the opposite party or petitioner. Otherwise, it will be confused.
It will be concluded on last day. I, my lord, relied on one judgment 2016.
Very well. What you want to rely, please.
Today, my lord, your lordships, my lord, perhaps remember against which impugn order the petitioner preferred this revisional application. My lord, this is the background of this case is, my lord, he sought for injunction in a suit. The temporary injunction refused by the trial court below. Against that, he preferred misappeal before the appellate court. Appellate court also refused the same. Thereafter, he preferred this honorable court under Article 227 of Constitution of India. So on last occasion, my lord, argued, my lord, this is the concurrent against the concurrent finding of facts. He, my lord, preferred this revisional application. So this decision reported in 2025, volume 3 SCC, page 266. I will just hand it up before your lordships, which says about the maintainability of this sort of litigation before the honorable court under either Article 226 of the Constitution of India or Article 227 of the Constitution of India. This is here we are under 227 of the Constitution of India challenging two order, which was, my lord, concurrent finding of the fact of the court below, my lord. So how far this honorable court can interfere over this impugn order?
My lord, relevant portion, my lord, I am reading and then I will hand it over to your lordships, my lord. My lord, Constitution of India, Article 227. Supervisory jurisdiction of High Court, setting aside order for permanent injunction while exercising power under permissibility, an order granting a permanent injunction when authority has given its independent and anxious consideration can't be set aside in a cursory and callous manner, more so under supervisory jurisdiction of High Court. A permanent injunction is an order of substance and ought to be treated as such. Setting aside permanent injunction while exercising supervisory jurisdiction under Article 227 by High Court deprecated specific relief Act 1963. My lord, this judgment against the permanent injunction, that is contested one. But here, my lord, at the expertise stage, my lord, his prayer was refused at the expertise stage. So without serving notice to the defendant to wait for a hearing of both parties, he preferred this revisional application. My lord, so the court says, my lord, the relevant paragraph 17. On the said settled proposition of law, we must make reference to the judgment of this court in Chandra Bharkar Sitaram Rao versus Asarata S. Gurum, the relevant portion of that SCC judgment. It is well settled that the High Court can set aside or ignore the findings of fact of an appropriate court if there was no evidence to justify such conclusion, and if no reasonable person could possibly have come to the conclusion which the courts below have come, or in other words, a finding which was perverse in law. So if there is perversity in the judgment of the court below, then certainly this court can interfere. But here, my lord, there is no whisper about any perversity of the judgment of the court below quoted by the adversary. This principle is well settled in D.N. Banerjee versus P.R. Mukherjee's case. It was laid down by this court that unless there was any grave miscarriage of justice or flagrant violation of law calling for intervention, it was not for the High Court under Article 226 and 227 of the Constitution to interfere. If there is evidence on record on which a finding can be arrived at, and if the court has not misdirected itself either on law or fact, then exercise of power under Article 226 or Article 227 of the Constitution of India, the High Court should refrain from interfering with such finding made by the appropriate authorities. My lord, here, my lord, the reason of refusal of ad interim order of injunction at the ad interim stage, because he relied on one judgment of city civil court wherein the property dispute between the parties has already been dealt with, and his predecessor's right was negated by the court below, and against them one appeal is pending before this honorable court, but no stay till today.
See, I will not go into all those factual aspects. Whatever is there in the record of injunction, I shall confine.
My lord, kindly consider
that is from their document.
Yes. From their document, I have not
from the plaint and from the petition.
From the injunction application he filed in the court below.
Yes.
As well as before this honorable court.
Yes, whatever is there, no, nothing beyond the trial court records.
Yes. In trial court records, that is there. In trial court record, my lord, that is there. In trial court record, my lord, kindly have a look, my lord, page. মেন সিওটা দিন।
Now question is, what is the decision? You have argued the factual aspects on the last occasion.
Yes.
You now confine yourself to the...
So from this judgment, I want to point it out that if the plaintiff fails to show his right over the claim he sought for, first his right to be established prima facie.
Very well. That you have argued, you have given you probably you have dealt with in your written notes also.
Yes.
And definitely, and
Yes.
you have a copy of this decision, you give it.
Yes. Written note, my lord, in page 2, my lord, kindly have a look, page 2.
Page, yeah,
Page 2 of my written notes of argument. Page 2.
Page 2 টা দিন।
Written notes টা একবার জজ সাহেবকে দিন। পাওয়া যাচ্ছে না? আগের দিন দেওয়া হয়েছিল।
কোথায় আছে রেকর্ডে? হ্যাঁ, এটা মেন পিটিশন পিও।
Written notes on behalf of the opposite party. না পাতলা, আমার কোনো মোটা জিনিস নেই। ওর পিটিশনের সবই মোটা। হ্যাঁ। স্ট্যাম্প দেওয়া থাকবে না ওই। CO ফাইলটা কি? My lord, kindly see in
This is the main file.
In CO file 1 page 150.
Yes, page 150.
150, my lord, second paragraph. On perusal.
Yes.
On perusal of entire record, I find from order number 215 dated 27 July 2015, order number 217 dated 22nd August 2016, order number 81 dated 3rd September 2007, that Chayarani, Iradatta, Robindranath De and Indira De were deleted by the order of this court. I also find that defendant did not challenge against this order before any upper forum. Hence, of legal heirs of Rothindo, Chayarani and Iradatta are not necessary party in this suit. Now, my lords, no document have been produced from the side of defendants that Sujoy Datta had any legal heirs. The person before your lordship's petitioner, he is claiming to be the legal heirs. Legal heirs, এটা কি? But kindly see. So, no document have been produced from the side of the defendant that Sujoy had any legal heirs. So, present defendant, present petitioner claiming to be the legal heirs of Sujoy De. Though on the death of Sujoy De, my lord, one can be substituted, but that does not mean he is the son of that deceased. If that be so, then this suit is not bad for non-joinder of parties. So, my lord, now, my lord, kindly see page 152. 152. Lordship got it, 152. Now, my lord, kindly come to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 12, 13, 15, 16, 17, 18, 19, 20. Well, after 20 lines from the top, on perusal,
Yes.
on perusal of those two judgments, I find that the property which was dedicated to deity by Nilmonide in no case will be considered as personal property or secular property. Rather, it is Devottar property. If that be so, then defendant number 2, my lord, kindly see here. Then defendant number 2 has no right to sell the said Devottar property to the defendant number 1. So defendant number 2, that is Sujoy or Sanjoy, they, my lord, sold the property, Devottar property. Against that, I preferred, my lord, this suit against the city civil code. So here they are apprehending that my client is constructing. Sometimes they are saying that they are trying to sell by he find that some meeting was there. So who was the wrongdoer over this property? In that suit, 982 of 1997, initiated by my client, that is against the defendant number 2, defendant number 2, that is Sujoy Sanjoy. They sold the property to the third party, defendant number 1, and that was negated by the declaration of that court. And against that, the appeal was preferred. It was held that they had no right to sell. So it is a Devottar property. They tried to sell. Their predecessor interest tried to say, sold it out, not tried. Sold it out, that was declared void. So, my lord, kindly consider who is the wrongdoer. Who tried to misappropriate the Devottar property. So, if that suit was decided, so it is between same parties, same Devottar property, it will hit by res judicata. They may prefer application for injunction before this appellate court where the appeal is pending. Without doing so, they preferred separate suit over the self-same Devottar property. So if they fail to show their prima facie title or right, how they can, my lord, establish that prima facie case? Why the court below would grant ad interim injunction? Court has done nothing wrong. There is no perversity in the judgment of the two courts below.
Anyway, that is ad interim injunction. So,
my lord, in order to
prima
have,
facie-
yes,
court was
that
satisfied.
prima facie includes he has to establish his right over the property. If he fails to show that he has no right, only mere
but it is the ultimate owners of the deities, Devottar property.
Yes.
Deity, court is the guardian of the deities.
Absolutely, my lord. And from 982, it is evident that his predecessor sold the Devottar property, and that those sale was negated by the court below.
So any allegations against him? Any allegations?
Yes, that, my lord, here that is 152. Kindly see the decree portion. Decree portion, kindly see. Page 150, 157. 157. So one wrongdoer subsequently can't approach the court for a ad interim injunction over the deity's property. 157B. 156, kindly come 156 first. What respect we got decree? Claim for decree for cancellation of 4 sale deeds dated 12th October 1991, registered with the Registrar of Assurance, Calcutta, book number 1 being deed number 15234, 15350, 15351 and 15352, 4 deeds in respect of suit premises 7A, 7/1B, 7/1C, 7/1D, Gopal Chandra Lane. They are all Devottar property. Calcutta 73, Bowbajar area. More fully described in schedule hereunder, and decree and declared the said sale under the 4 sale deed dated 12th January 1991 in respect of the suit premises is void. Well, let kindly have a look. Is void and liable to be cancelled and of no effect, and the same should be
Delivered up.
Second, decree for declaration, the defendant number 2, had or has no right upon whose title he is claiming, that defendant number 2 has no right and or entitled to or transfer the suit premises to defendant number 1 and or any outsider by virtue of alleged sale as made by him under 4 sale deeds 12 October 1991 of the suit premises, which is the Devottar estate and property of the debtors plaintiff number 1. Absolutely. So, my lord, who committed crime over the Devottar property? Who tried to use up the property of the debtors property? None but that this petitioner's predecessor, alleged predecessor. So can he come now? What right he has? If his alleged predecessor having no right, that was declared by the appropriate civil court, then what right he has? I am putting question to myself, my lord.
Yes.
For that reason, court below, my lord, there is a judgment passed by Justice Honorable Justice Rajesh Bindal and Sanjay Nath in recent judgment. It is stated that it held that one who wanted to have an order, he must show his title over the power, his right. First, he established his right. What the defendant will prejudice by grant of that relief, that is not material. First, he has to substantiate what right he has over the property, what authority he has. Here, my lord, he has no authority. From this decree, it is clear. And they are not Sebayat, my lord. Kindly have a look. Prayer D, decree for declaration that the suit premises mentioned in the schedule hereunder are the debtor plaintiff number 1 and the plaintiff number 2 to 8 are Sebayat. Plaintiff number 2 to 8 Sebayat of the debtor plaintiff number 1 and are entitled to manage the administer the said Devottar estate of the debtor plaintiff number 1 and earn and collect terms, rent issues and profits from the occupiers and tenants in occupation of the suit premises and to reside and hold in the possession of the suit premises and enjoy the same as Sebayat of the said debtor. So defendant number 2 is not the Sebayat. Next, permanent injunction restraining defendant number 3 for CMC authority to effect mutation in the assessment record in the name of defendant number 1 as owner of the suit premises or any portion thereof. Permanent injunction was given to the CMC to mutate the property in favor of the new purchaser. Decree of permanent injunction. So when there is a permanent injunction, my lord, so how he can claim, my lord, the ad interim order of injunction over the said property? My lord, kindly have a look.
Restraining the defendant number 3 and 4.
Yes, corporation for mutation.
And defendant number 1 is this.
Yes, defendant number property was transferred in favor of the defendant number 1 by defendant number 2. The predecessor alleged predecessor interest
From the plaintiff.
Of the plaintiff. Yes, my lord. So how he has right? But kindly, your lordship, kindly see this decree portion, which will ascertain, from which it will safely ascertain if there is any right, and will kindly have a look at a glimpse of this judgment. Lekho 2025 3 SCC page 266. খুব ভালো শর্ট জাজমেন্ট পড়ো, অন্য কেসে কাজে লাগাতে হবে। মানে that's my entire submission, man. I will furnish a Xerox copy of this judgment.
My lord, in turn, my lord, he actually wrongly entered into the argument because he pointed out the degree in respect of title suit 982. That is the separate property, my lord. Absolute separate, my lord. He pointed out, my learned brother pointed out, in respect of 7A, 7B, 7C, 7D.
7 by A.
7 by A, 7 by
7
B.
by 1B.
1B. But
1C and 1D.
yes, but now in respect of our case is different from that property. My property is Schedule A, that is in respect of 94 Beliaghata, 74 Beliaghata, and another property is 6 Gopal Chandra So these are two different property. So judgment in respect of another suit is another property, not in our property. So in our property, that is Schedule A and Schedule B as depicted in the plaint and in the injunction application, is absolutely.
No, these records are your records because you have relied upon this.
I am.
It is your document before the trial.
Yes, yes.
As well as before
My lord,
this court.
I am on the point, my lord. Why I am relying upon? Because of that is a genesis of the case. Because originally Nilmoni De, that is the owner of the property, and he during his lifetime executed the will, and the will was granted as and thereafter the document was executed, my lord. On last occasion, I placed reliance the Orpon Nama, page 87 to, my lord, page 94, 95. So that is the crux of the matter. There are three properties, my lord, in the document which have been placed wherefrom I collected the document collected in respect of that suit. That is why I placed before the learned trial judge. I have no documents at all. But as these documents have been placed before the learned city civil court, wherefrom I collected it by way of certified copy, whereby it has been appeared that there are three premises, 7, 6, and 74. So my case is that in respect of Beliaghata police station and Gopal Bose Lane. So that is the two properties, not in respect of the property where the decree passed by the city civil court. So the issue is that why I am annexing these documents, because of to clear my genealogical era. That is why I obtained the documents whereby it is palpable clear that there are three properties and two properties are within the jurisdiction of city civil court, Sialda court, and file the suit for rights of sebaitship. Nothing more that I am not claiming the ownership as a co-partner or co-sharer, only right to sebaitship. Property already devolved upon the deity's property. So to protect the property as deities, I came up with the suit for a partition of my sebaitship rights. And now, my lord, on last occasion, my lord, the degree has been challenged. That degree by my uncle, who is the defendant to the said suit. And during the lifetime of my uncle, the appeal has been preferred. And during the pendency of the appeal, my uncle, as being the appellant defendant number 2, expired. And I filed the application for substitution. And in presence of my learned brother, the application for substitution was allowed. So I continue the appeal before the division bench. Now the genealogy.
No state.
No in regard to the genealogy, my lord.
Then Devottosi already decided in that suit.
That suit, that is a separate suit.
Separate
In
suit,
respect of that property, not in respect of these properties.
Sebaitship already decided.
No.
What more if
Sebaitship decided in
One by one, let us
Yes,
go one
yes.
Sebaitship decided in respect of that property, and which has been challenged before the honorable court. Appeal is pending. Now, my lord,
appeal pending, no stay.
my lord, the very crux of the matter in my supplementary affidavit, my lord, kindly see page 157.
supplementary affidavit টা দিন।
Supplementary affidavit. সাপ্লিমেন্টারি বড় আছে, পাতলা না বড় আছে। দেখুন না সাপ্লিমেন্টারি পেছনে সাপ্লিমেন্টারি লেখা আছে। হ্যাঁ My lord, kindly see page 174. Page 174.
Yes.
174. My lord, Sanjoy De, that is my uncle, who preferred this appeal against the suit which have been mentioned by my learned brother. My lord, in the order, my lord, my learned brother was present, appeared for the respondent number 1, Mr. Krishna Das Prodda. Now, in view of the affidavit disclosing the family tree and justifying that the applicant is a legal heir and representative of late Sanjoy De, the appellant, the application for substitution being can number such and such is allowed. Applicant is otherwise major, sue juris, the right to sue survives. So when the order was passed, my lord, kindly see 13 December 2019. So appeal court allowed my application for substitution. Now, my lord, in page 57, 157.
Yes.
157, my lord, my learned brother's client, that is the opposite parties, my lord, in cross-examination, resumed to dated 25th November 2021. That is after the order passed by the Honorable Division Bench. In the year 2019, the order of substitution was passed. Now, after 2 years, when the cross-examination was started, my lord, on 2021, he stated, my lord, kindly see line 17, 18, 19, 20. 17, 18, 90, and 20. Satyendranath De had 2 sons. He stated in cross-examination, his client stated on doc, Satyendranath De had 2 sons, namely Sujoy De and Sanjoy De. Sujoy De and Sanjoy De are my father and uncle. He admitted on cross-examination. And now, my lord, and both of them had been died being unmarried when cross-examination in the year 2021.
That means they are your father and uncle.
Yes.
Your uncle may be unmarried.
Yes. No. Yes.
But
No.
question is,
Father unmarried.
no. Question is both of them
Unmarried. So when
both of them died unmarried.
Died unmarried.
They and Sanjay they are your father and uncle.
Father and uncle. Now, my lord, when please. No, my lord, only I pointed out that in the year 2021, he at the doc stated before the learned trial court that both are unmarried. But in the year 2019, that is way back before 2 years, he stated that yes, substitution was allowed in his presence. So it is the absolute case of perjury. I filed the application for perjury before the learned consent court. This is the actual scenario, my lord. In the year 2019, my locus standi has been admitted.
No, it has come out in cross-examination. That's something.
He admitted on doc.
That they are Satyendranath De had 2 sons, Sujoy De and Sanjay De.
Sanjay De.
And both of them died unmarried.
When?
In substitution application, you are substituted in place of?
My uncle.
That is?
Sujoy De,
Sujoy.
Sanjay. Now, my lord, what is the contradiction, my lord? In the year 2019, my application was allowed. In his present, and after the lapse of 2 years, he stated
This is a subsequent statement.
subsequent. So that is the false evidence has been adduced before the learned trial court, and is a case of perjury, and immediately I filed the case of perjury. That is under the consideration of the learned court.
Very well. Now come to the facts.
So
anything in reply?
So
Clarification.
So in that event, my rights are there in respect of that property. In which property he adduced? In respect of 6, that is Schedule B.
So you have substituted in case of a different property which is not the subject matter of the suit.
Yes, but when the opponent has been adduced in cross-examination in respect of my B schedule property, 6 Gopal Bose Lane. My lord, kindly noted it. In respect, this evidence has been adduced in respect of 6 Gopal Chandra Lane, my lord. Kindly noted it. That is the Schedule B in respect of my case before the Sialda court. My lord, kindly noted it. This evidence adduced in respect of 6 Gopal Chandra Bose Lane, that is the Schedule B of my case.
Of the plaintiff.
Of the plaintiff. Schedule B. So admittedly that my rights are there.
So if that is not accepted with regard to other scheduled property,
yes,
these were not the subject matter of the suit.
Yes.
A particular scheduled property was the subject matter,
yes,
of Mr. Poddar's suit.
Yes, yes.
But so far the other schedule, they were not subject matter of the suit.
Yes. So that is challenged before the Honorable Division Bench.
No, that is challenged, but all the schedules were not subject matter of the suit.
Yes.
So all are deities property.
Yes.
Yes.
Court is the guardian of the deity.
Yes. So that is to be noted that in respect of B schedule property, my case, adduce the evidence. And my lord, what happened, my lord? In that particular case, it is a case of eviction. And my lord, plaintiff is very much clear for reasonable requirement, my lord. When the property question is a deity's property, it is on his admission. So the suit cannot be maintainable as per reasonable requirement for his own use and occupation. That is the plain case in connection with wanted to get a degree.
No, not your case.
No. But suppressing that, in that case, he suppressed the legal heirs of the Satyendranath De.
Anyway, so that is not taken into consideration here.
So in that case, my lord, when I came to know, I obtained a certified copy. And in that case, my lord, I filed an application under Order 21, Rule 101. So that is for awaiting for adjudication. So my rights are there. It is admitted. And immediately when suppressed it, I came to know.
Plaintiff's case, that means the petitioner plaintiff's case is they are the heirs of this particular person whom you have described.
Yes. So the entire this evidence, my lord, kindly see, look upon the entire scenario, genealogy has been stated here. In that particular day on cross-examination, 25th 11/2021, entire genealogy has been appeared. And my substitution was allowed in the year 2019, and after 2 years, he denied my right. So it is absolutely a case of perjury. I filed the application under section 340. That is pending before the learned. Now this is the scenario. Now he argued on the point of only that suit. That is not the property of A schedule and B schedule. Argued in separate suit. So whatever may be the rights of the appellant or my uncle, that is to be adjudicated by the appellate court, Honorable Division Bench, that is pending now. Now in this particular case, my lord, I have able to prove my prima facie case. What prima facie case? Prima facie case is that I have some rights as a surviveship that is appeared from the order of substitution and the evidence. So that is why I collected the certified copy and annexed with the supplementary affidavit and my original application. There are some rights over the property in question. And at the time of...
Did you furnish in your plaint or injunction any documents that you are performing your function as a Shevite?
Always close vigil because of my...
No, in any documents furnished?
I always knock the door of the local administration because of I always went to the shoot property at Beleghata and...
This is your case, but any document...
Performance of duties. Performance of duties.
Any documents you have furnished that you are performing?
Because the miscreants are very much alert to capture the property. That is why I pray for injunction to restrain them. Because the miscreants are always told in presence of me that they have been engaged by the opposite parties. So that is why I made the repeated complaints before the concerned police station. And immediately, when my lord passed the order, when the learned additional district judge already directed the police to comply the order of the my lord's order. And even that the police are not active, that is why I preferred the writ application before the Honorable Court. Because I always visited the spot in both the Schedule A and B and saw that miscreants are always threatening to capture the property.
So shall I send a special officer to see who are there?
I filed the application. And
whether you are discharging your function as Shevite or not.
My lord, if my lord appoint the special officer, my lord.
At his cost.
No.
Yes.
Either of the party, any advocates of the party, because there is no earn from the property.
Anyway, you see, whatever it is, if the petitioner is filing the case, pursuing the case, initial stage it has to be borne from the plaintiff petitioner.
Yes.
My lord, the situation is so endangered to the life. When I visited the spot, the miscreants are there. Miscreants are creating disturbances, threatening to construct the building.
So that miscreants at the instigation of the defendants.
Defendants. They told, and that is why I made a complaint. আচ্ছা এটা কমপ্লেন দিয়েছিলাম সেই আরে এতে দিয়েছি একটা সাপ্লিমেন্টারি
Yes, anything else to add? You have filed your documents.
My lord, in regard to
File your written notes.
My lord, I am submitting, my lord, the Xerox copy of that judgment and the further one written notes today. My lord, conclude it, my lord. Let's see.
My lord, kindly noted.
Our note.
Can 8, my lord. Can 8, my lord.
No, I'll not take up any application. I'm hearing out the matter finally.
My lord, that can, my lord, he is seeking, my lord, stay of that.
Nothing.
My lord,
Because at the purge of disposal, I'll not.
Can 8 people are spare?
My lord, in regard to the approach,
Police in action,
bona fide approach and reasonable apprehension, that is to be the reasons for which.
Anyway, I shall.
In my plaint and injunction application, I have stated categorically the reasonable apprehension of imminent danger caused at the instance of the opposite
In
party.
regard to the merits of the case, anything else to add?
My lord, in regard to that, whether I am vigil or not, that is why this during the pendency of the revisional application, the miscreants are very much alert and they are trying to grab. That is why, my lord, I annex the application, my lord.
Anyway, these are there in the record, your applications. All applications are there in the record.
No, my lord, in respect of my Can 8 application.
No, it is there in the record.
Yes, my lord, kindly see the Can 8.
যেটা ejectment should তুমি stay চাইবে kindly see can 8
No.
stay of
No.
execution correction of the ejectment should
Where is the scope?
Granted by premises small causes court.
No, any interim protection you see, as because the interim order was there, so any police protection you can approach the trial court.
Yes, my lord. Already, my lord,
Yes.
the learned additional district judge, my lord, directed both the police station of Boubazar and Beleghata to implement the order of the my lord's judgment. even that the police authority are failed to act in accordance with law. So that, my lord, I prefer the writ application, my lord. Writ application is pending, my lord. Because of that, the situation is very tense and alarming in the locality. Because of the criminals are active, they told my client was there, threatened that they are engaged by the opposite parties. That is why my safety and security are unsafe. At this moment, I seeking relief before the Honorable Court by filing Article 226 of the Constitution of India.
Anyway, so anything
So
else
at
to add?
this moment, the case is very much fit for allowing my application, my lord, keeping it open for hearing. The injunction application as pending before the learned trial court. My lord, in regard to that, in my written notes of argument, written notes of argument, my lord. In written notes of argument, কিসের কথা বলছো? তোমাকে দিয়ে কি হবে? My lord, in page 134, my lord,
Yes.
134 is a my lord's judgment in respect of Baruipur case, wherein the interim order was initially passed by the learned trial court, thereafter turned down without showing any reason, appeal preferred, appeal court refused, and thereafter preferred the revisional application. In this revisional application, it was allowed, order dated such and such, passed by the learned Civil Judge Junior Division Second Court at Baruipur in title suit number such and such, set aside. The ad interim order of injunction granted by the learned trial court on such and such is restored, and the same is to continue till disposal of the injunction application pending before it. The learned trial court is directed to decide the application for injunction pending before it in accordance with law. So it is a very settled proposition. Elaborate discussion has been made by this judgment. Very elaborate judgment is. And another thing is that my lord, page 109. Page 109, that is a Supreme Court judgment, my lord. Page 109. In that judgment, page 111 is the very much relevant. Page 111. Last paragraph. It may not be appropriate for any court to hold mini trial at the stage of grant of temporary injunction, as noted by the division bench, and there are two documents which indicated that there was prima facie case to be investigated. Unless the sale certificate is set aside or declared to be a nullity, the same has legal validity and force. So whatever may be the documents I have placed before the learned trial court, so that should be decided on merit. So at the stage of temporary injunction application, even that, but in my case, it is a stage of ad interim injunction. But even that, the temporary injunction application hearing, the trial court has no power to take it mini trial. So if any documents I have placed it, whether wrong or right, that should be decided at the time of trial. That is the concept or ratio decided by the Honorable
I shall consider these decisions.
Yes, my lord.
Yes, record an order.
My lord, I am submitting the copy of the judgment and the
Submit it.
written notes today.
Along with your compilation.
Compilation, my lord, only two judgment, my lord.
Okay, give it tied with your written notes, otherwise it will be misplaced.
It is in the, it will be in the written notes.
Yes. Yes, learned advocates for the parties are present. Heard learned advocates. The hearing is concluded. CAB. Let the yes, Mr. Poddar, have you filed your written notes earlier or today?
Yes, yes, that was since it is misplaced in the file of your lord.
It is only judgment.
I am only one judgment I am annexing, and the written notes which was filed on the last day, that I filing today again. Today I am filing.
Only that
today.
judgment.
Only.
Anyway, that is not necessary because
Yes,
written
yes.
notes you have earlier filed.
Yes.
You also filed your notes earlier. Yes. CAB.
My lord, interim order be extended.
Okay, the interim order stands extended till further orders.
Yes.
ফাইনাল কিছু দেবে না, ইন্টারিমটা নিয়ে যাচ্ছে না। ডিপলি অবলিক।